May I please, not one eviction matter, may I pray for listing today itself, my lord, at
Today,
today.
why today?
Because notice short sharp on, my lord, 29th of December 2025,
Hmm.
recently, my lord.
December 29. So what were you doing? Why today?
Now, in between, my lord, there are some holidays.
We'll see. You serve copies of the respondent.
Yes, we have already, yesterday it was filed.
You have to inform them.
Yes,
that-
I will inform you.
I will inform them.
Deep blood pressure.
But I have a similar prayer, man. If time permits, man.
Eviction.
No, man. This is an eviction. This is a construction law, Milord, Obama Patta land, Milord. This started, Milord. By far, without any compensation, without requisition costs, Milord.
Their provisions are there. Why an unlisted? Provisions are there under the act that if you're unhappy with the compensation, you go and
Nothing has been
educate the matter
no
before the
process has been
authority.
initiated, Milord. No process has been initiated, Milord. In fact, the construction has started.
So construction started, but we can't stop it if it is already acquired. It's a
Not
question.
requirement. Not requirement. No process was initiated at all, Milord. Obama Patta land. By
Alright.
far, kisi mein Patta land.
Alright.
Lord,
Another eviction.
similar eviction matter, Milord. Filed yesterday, Milord, for today, Milord.
You have to inform the other side.
Milord, filed yesterday, copy served, and today morning I have also informed. Milord.
You have to inform them that.
Yes,
you are
yes,
getting
Milord, that
eviction.
today, Milord, I am moving it today as an unlisted. I have informed, Milord.
Alright.
With my lordship. Oblige.
Lordship, I have a request for listing a admission item on 27th, Lordship.
Admission,
Admission item, Lordship, 27th of January.
28th,
28th, we have some other matters. On 27th, it will
then
be.
30. 27th is a Tuesday. Unless the matter is ready for admission hearing, how do you know whether the pleadings are complete or not?
The pleadings are complete.
All
Lordship.
right, 27th.
Lordship, item 42.
Hmm.
I'm appearing for the respondent. Lordship, my name was not shown, so I missed the matter. My learned friend is appearing for the petitioner. Lordship. May come up to 4 weeks.
42.
Lordship.
Matter stands deferred to be listed again after 2 weeks on a
Lordship,
request
my
made
name
by
will kindly
Mr. SCKL as it is submitted that his name has not been reflected in the course list. And he had missed the matter. I miss
Jeremy be continued, Lordship.
P. Borwa.
Our Burwell.
R. Borwa appears for the Senate. Interim order passed earlier will continue this matter on 30.
Lordship. Much.
Lordship, I may be allowed to make 3 petitions listing for admission, but the matter is about land acquisition and matter is settled. The respondent tried affidavit, they are ready to compensate the landowner.
30 January.
Lordship.
May I plead your Lordship? Lordship, I beg to mention item number 3, my lord. I'm praying for adjournment for 2 weeks, my lord.
There is some interim order.
No, my lord.
Item 3 on the request made by the counsel for the petitioner stands deferred to be listed after 3 weeks.
Oblige your Lordship. May it please your Lordship, I beg to mention item number 41, Lordship. Kindly matter may be adjourned for 2 weeks, Lordship.
Why?
JUNM Lashkar is out of station, Lordship.
41 adjourned for 2 weeks on a request made on behalf of Mr. JUNM Lashkar, counsel for the petitioner. Yes.
Oblige.
Please, Lordship. Lordship, with the consent of the other side, I beg to mention item number 44, Lordship. Can it be taken up after the bivouac?
After
Bivouacation.
Your Lordship, I am appearing for the petitioner. May I pray a fixed date, 21st of this month, Your Lordship.
item 44 on a request made on behalf of the respondent, matter stands deferred to be listed again on 21st.
Yes, Your Lordship. Much. I love that.
May I please, Your Lordship? I beg to make a mention for listing of 3 items for admission after the Bihu vacation, Your Lordship. These are tax matters, Your Lordship.
21st.
On a hearing date, Your Lordship, if possible. 22nd,
20.
Your Lordship. May I please, Your Lordship? Lordship, I beg to mention item number 39, the concern of the other side, Your Lordship. Can I be listed after 3 weeks if possible, Your Lordship?
Item 39 to be listed after 3 weeks on a request made by the counsel for the petitioner. Mr.
T. Chetri.
E. Chetri.
Much obliged.
May I please, Lordship? Lordship, I beg to mention item number 6, Lordship. Matter may be taken after 3 weeks, Lordship.
Why?
Lordship, we have some personal difficulty, Lordship. In the meantime, we will file additional affidavit.
Counsel for the petitioner, Mr.
I am in, Lordship.
I am in. Prays for 3 weeks' time to file additional affidavit in the matter. Matter stands deferred accordingly. Placed after 3 weeks.
Wait, please, Your Lordship. The item number 5 of today's list.
already
It was supposed to come up for admission. Notice was issued on 3rd of December. My friend has
Already, I'm appearing.
Notice issued.
Lordship,
Notice issued on 3rd of
Notice
December.
already issued.
Item 5 to
Item
be
5, yes.
listed for admission. As
Hmm.
notice was already issued in the matter. Is this matter on 21st?
20
Thereafter, Lordship, because Lordship, I am awaiting instructions, Lordship.
27th.
In
28th.
the month of February, Lordship.
Can it be on 29th? 28th. I have. Good.
2nd of February.
Lordship.
Yes.
2nd of February.
Lordship.
Much older.
May I please, your lordship, my prayer is for adjourn for the day, lordship, item number 62. I am for the private respondent newly included, lordship, but today is my senior is not
Have
available.
you informed the other side?
We will inform lordship.
Huh?
We will inform lordship.
No, you inform them first. You have to inform them before you make a mention.
Just I reached that's why, lordship.
You make them, you inform and come and make a mention. Alright?
Or motion, Matthew 1.
My lord, this case was filed on apprehension of eviction, my lord. And we kindly peruse the last order, my lord. In fact, my lord, same situation still prevails. That is my instruction, my lord. 7/11/2025. Paragraph 5 was my submission, my lord. Mr. So-and-so submits that the forest department in Assam is carrying out the survey to find out illegal encroachers inside reserve forest. The petitioner should not have any apprehension at this stage. Till such verification is made and found out that the land is not included within the reserve forest, the learned so-and-so submits.
In similar matters, there, I think there was a order by a division bench. Of
Yes, madam.
This court.
This division bench has direct framed a guideline for the government to follow, my lord. That we are following. That stage has not yet come, my lord.
Okay.
If my lord peruses paragraph 6, my lord, that was also my submission, my lord.
Hmm.
Further contents that even when they arrived at a satisfaction that the petitioners are in encroachment of land under reserve forest, they will comply with the procedures prescribed by the learned division bench under its order dated so and so, more particularly at paragraph 20. Wherein time of notice and period of eviction has already been prescribed. So, my lord, this stage will come when, my lord, we complete the survey and the joint verification. That is presently going on, my lord.
Yes.
My lord, we have two concerns in this petition because, my lordship, on District Land Advisory Committee, Gwalpara passed resolution number 7E approving allotment, my lordship.
No, all this will come once they complete their
Yes, my lordship.
survey.
That is, that
So
will
let the
complete the
survey be
survey
completed.
and because
Yes,
because we are staying there and there is a recommendation also for
But they have
allotment, my
not, they
lordship.
have not started evicting you.
Yes, my.
not even issued notice, my lord.
Ah. So let
We
them
are
complete.
also seeking, my lordship, by this, by means
So
of.
we'll
this-
record the submissions made in para 5 and 6.
Yes, ma'am.
Then close the matter. Giving you liberty to come back again. If you are
Yes,
still
Allotment
again.
also, my lordship, because
Huh?
we have been seeking allotment, my lordship. They are not.
Mr. Council, no one is questioning your allotment. You are apprehending eviction by the forest department
Yes, my lord.
as according to you, this is an allotment done by the revenue authorities, not within the forest area.
But not allotment, main recommendation has been made.
All
We
that
have, we are
recommendation, but
coming.
this area is not within forest area. according
Yes,
to you.
yes, my lordship.
So let them complete the survey.
Yes, my lordship.
Once that is done, whatever steps the
But
procedure prescribes.
Only that much may be
followed.
recorded, my lordship, for our,
Hmm?
that liberty may be given that.
Yes, yes.
uh,
Heard.
We will come, my lord.
Counsel for the parties. Petitioners are before this court apprehending you for the forest department from the land which have been sought to be recommended for allotment by the district land. What is that? District Land Advisory Board,
Yes, my lordship.
District Land Advisory.
Pass resolution 7E, my lordship, on 3/11/2006.
Walpara. ID, resolution number 7E. Dated 3/11/2026. That's 3/11/2006. Stop. On 7/11/2005. This court permitted while permitting the respondents to complete their instructions, recorded the findings, recorded the submissions of the learned additional AG appearing for the respondents as under. There are 5 and 6 extract. Well, today when the matter is called up, Mr. Goswami submits that the position still remains the same. The forest department is undertaking the survey. The survey is not yet complete. As on date, it is not known whether the petitioners will ultimately have to be evicted from the land that they claim to be under their possession. Stop. Mr. Goswami fairly submits that once the survey is completed, the forest department will take all prescribed steps, all steps prescribed under law. If the need arises to resort to eviction of the settlers in the said forest, reserve forest area, which may or may not include the writ petitioners. Considering the submissions made, the bar, this court is of the view that at this stage, the writ petition appears to be premature, inasmuch as on date, it is not known whether the land which was recommended for allotment to the writ petitioner would fall within the reserve forest area, as the survey undertaken by the forest department is not yet complete. So, under such circumstances, this writ petition stands closed on the basis of the submissions made by the learned additional AG, Government of Assam, that the survey by the forest department is still underway. The forest department has not yet concluded as to whether the land sought to be allotted to the writ petitioners would fall within the reserve forest area. And if the said land does fall within reserve forest area, then the procedure prescribed by law will have to be taken before. Under such circumstances, we deem it appropriate to close this writ petition at this stage, directing the forest department to conclude the survey. And you'll publish the findings of the survey?
Yes, my lord. So that will be good, my
It
lord.
is not be
because-
published, my lord, then the notices will be issued, my lord.
No,
It's not a
no,
survey.
my lordship.
There is no
as
scope of
allotment,
public-
my lordship. They have, the
In-
government
in
What was
the-
on it?
proposed for
Once
allotment.
the survey is completed, and if any settlers are found to be within the area of the reserve forest, then appropriate notices will be issued. Stop.
In terms of, my lord, division bench order, 250,
In
readable
terms
copy.
of the directions contained in the order dated
Order dated, my lord, 18/8/2025.
Hmm.
Passed in writ appeal number 251 of 2025.
18/8/25, passed in writ appeal 251 of
Yes, that will follow, my
2025.
lord.
Stop. Needless to say, if the petitioners are still aggrieved, they will have recourse to recourse to this court again. With the above narration,
We can also submit our documents to them, my
No,
lordship.
that stage
because
has not
allotment-
come, my lord. Then
That
what-
proposal, my lordship, 101 eligible encroachers. We have some document, we'll submit that, they can hear, my lordship.
That stage will
Once-
come, my lord, when we
once
issue
the
notice.
notices are issued, you submit.
Then that,
Yes,
stage,
ma'am.
that as per division bench, my lord.
We may be included, our voice may be hard, that is, we are
It will Kori, my
It
lord.
is already there in the division bench.
Yes,
order.
that will. follow.
highly obliged, man. Happy.
Hmm.
This is same, my lordship.
Not same, not same. There's a different forest, my lord.
Mhm.
All were evicted, but for these three petitioners. They wanted for a fresh verification. Twice we did the verification. We have filed a report, my lord, along with the map. The pleadings are complete. If I may suggest, my lord, since it will take some time, my lord, since there is an interim order operating in their
Yes,
favor, my lord, let's be fixed on 20th, my lord,
Yes, my lord.
20th of January, my lord. Then it can be finally decided, my lord. Pleadings are complete. We have filed a PTP, they have filed rejoinder.
All right. Notice is not issued here.
Notice or not issued, my lord.
But counsel for parties. Although notices have not been issued in the matter, the pleadings have been exchanged by the parties. Accordingly, it is listed 001.
My lord.
At the motion stage. And an attempt will be made to dispose of the writ petition. of the
Deeply.
next stage.
Highly obliged, my lordship.
Lordship, I
Lord,
prayed for some
please.
time. Notice may be issued, Lordship. I have not received the instructions, Lordship.
But
But-
FIR not registered.
No, no, my lord, FIR registered. But my lord, there is no action on the part of the police. We have not been allowed to perform our works, my lord, by the some of the locals by using man and muscle power. My lord. Then when we approached the police in fact registered the FIR, my lord, but thereafter no assistance of the police, my lord. We are now, my lord, in such a situation that though we are required to carry out the work, we have been restrained, my lord. By
You have
using force.
recourse to,
We have approached the superintendent of police also.
you have recourse to proper forums under the
My lord, we have,
DNSS.
my lord, we have already approached the superintendent of police also, my lord. That's why, my lord, this honorable court issued the notice. In fact, if there
Notice
is
has
no,
not been issued.
Not issued.
not issued, my lord.
Only for instructions.
So get your instructions, what steps have been taken?
My
Why
Lordship,
notice issued?
we have communicated, Lordship, not yet received.
Who communicated to whom?
Lordship,
Communicated to whom?
all the respondents, Lordship, communicated to all the respondents.
No, who's supposed to give you the report? Not all
The
this.
officer in charge and 5 and 6, Lordship. Respondent 5 and 6.
It's regarding the, FIR, steps
Lord.
taken pursuant to FIR.
Lordship.
It heard counsel for parties. The grievance of the petitioner is that although FIRs were lodged, 2 FIRs were lodged on 16/9/25 and 20/11/2025 before the appropriate police station. No action has been taken. So on 19/12/2025, Government Council was permitted to complete his instructions. Stop today. The matter is called up. Mr. S.S. Roy, Government Advocate, prays for further time. List matter be listed again on 28th, 30th, 30 of
Lordship.
January, on which date the learned Government Advocate will obtain required instructions from the respondent number 3, the Superintendent of Police,
3 and 6.
and the officer in charge, Romania Police Station.
Lordship. Obliged.
Obliged.
The next date fixed. List accordingly. Kundu. Video.
Item 7.
Yes. Any instructions?
Lordship, today only I am appearing, Lordship, on, for respondent number 5, Lordship. I maybe allow some time to take the instructions.
Respondent 5 is
HDFC Bank, Lordship.
MS Y Yasmin appears for the respondent number 5. She prays for some time to complete her instructions. Although BC request was sought for, none represents the petitioner. List this matter again for
Served, Lordship.
2 weeks.
Copies have not been served to us.
Doesn't matter, you get instructions, you will direct the court master to take a copy, give you a copy.
Much obliged, Lordship.
Item 8.
In this case, my lord, the petitioners have challenged the eviction on the ground that they were temporarily settled inside forest, my lord. So I have received instructions, my lord, but I think it will be appropriate if I file an affidavit, my lord. They will also get a chance of rebuttal, my lord. But since my lord, there is an interim order operating, may I pray, my lord, immediately after the leave vacation, my lord.
Let us issue notice.
Mal.
Let it
Since
be,
they
my
are
lord.
filing an affidavit.
Let it be, in the motion states, my lord, there is some urgency, my lord.
All right. Mr. A.R. Wing for the petitioner, Mr. P.N. Goswami, learned additional legal, represents the
before-
forest department. Mr. Goswami submits that he is posting the necessary instructions, we would like to bring it on record by filing in affidavit.
Second, my lord.
Mr. Goswami submits that there is an interim order operating in the matter. and therefore Matter be listed for,
That will find time limit.
listed at the motions stage. And in an attempt can be made to dispose of matter on the next date fixed. List on
23rd or 24th, my lord. I'll try to file the affidavit on 20th, and they will get a chance of my lord, reply.
28th.
My lord.
My lord, interim order is operating. that
Interim
we-
order passed earlier will continue till the next date fixed.
Well,
Deeply
Apply.
obliged. Was applicant able to get?
Hmm?
Applicant.
Try.
May it please your lordship. Lordship, herein the petitioners are elected members of Gaon Panchayat, lordship. Ward number 1 and ward number 5 of Chandrapur, Bolia, lordship. Herein they are challenging the annual action plan submitted by the president and secretary, lordship. They have submitted a representation that has not been considered, lordship.
Representation before whom?
Representation before the Chief Executive Officer, Jila Parishad, Hailakandi, lordship. Is 55 annex 4.
Any instructions?
No, lordship, need to obtain instructions.
Mr. S.J. Sharma for the petitioner, Ms.
P Thapa.
P. Thapa. Appears for the PNRD.
Lordship,
The petitioners are members of the Gaon Panchayat.
Gaon Panchayat.
Which Gaon Panchayat?
Chandrapur, Bolia Par.
Chandrapur,
Boila Par.
the petitioners are elected members of Gaon Panchayats of Ward number 1 of Chandpur. Chandpur or Chandrapur?
Chandpur.
Chandpur Boalipar. Then Ward number 5 of that are elected members of Ward number 1 and Ward number 5 respectively of Chandpur Boaliapar Gaon Panchayat. Is the grievance of the petitioner that various development schemes in plans under the scheme within quotes Amargaon, Amarasam, quotes closed, are required to be approved by the Gaon Sabhas, but the president and secretary of the Gaon Panchayat prepared and submitted the action plan on 29/11/25 for the year 24-25 without conducting the Gaon Sabhas. Stop being aggrieved, the petitioners filed a representation before the Chief Executive Officer, Zila Purukul, on 3/12/2025. Stop the same, however, although received, has not been disposed of. So, where MS P. Thapa, learned standing counsel, PNRD department will obtain required instructions on the matter, list accordingly.
Till then stay may be,
Hmm?
till then stay may be prohibited.
No stay. Why stay?
So, if, since the action plan submitted, the fund distributions are discriminated.
We'll examine that. Why should there be a stay, blanket stay like that?
I can claim.
The non-compliance of the order dated 26/8/25. Page number 19, paragraph 32, madam.
Heard counsel for parties issue notice. returnable 4 weeks, steps on responding by speed post as well as usual course within 2 weeks from today.
August.
Yeah, because. That contempt petition, my lord, on that's order date is 70 to 25, my lord. Relevant, my lord, page number 13, the operating part, my lord, page number 30.
Third, council for parties issue notice returnable 4 weeks, steps on respondents. Respondent by speed post as well as usual course within
Hi,
2
Joker.
weeks.
Suppose by issued under section 74 CGST Act, madam. Section 74 requires, madam, there has to be suppression of facts and order, madam. The reply was submitted, order was passed. In the order, madam, the authorities observed there is no suppression of fact. However, the demand of interest was raised. Lordship may kindly see page 102, madam.
Hmm.
Para 12.9, madam.
Hmm.
Very good. In view of the above aforesaid discussion and findings, I hold that it is not a case for invoking the provision of section 74 of CGST oblique AGST 2017 for demanding GST. Now, my lord, he is admitting that there is no ingredient section 74, my lord. And now thereafter, my lord, he has dropped the other demands, but he has raised the demand of interest, my lord.
What is wrong with his finding here?
My lord, since my section 74, he himself admitting, my lord, that he has no jurisdiction under section 74. Therefore, he has to drop this proceeding, my lord. He has partly dropped, my lord. Lordship may see the demand, which page 105, my lord. It starts from page 104, my lord, order. After observation, page 104, the order part, my lord. He has dropped other things, my lord, but he has confirmed demand of interest, my lord, para 17.1, page 105, my lord. Rest he has dropped, my lord. And he is himself admitting, my lord, that he has no jurisdiction, my lord, because of there is no ingredient section
No,
74.
he says it is a case of delayed payment.
Delay payment.
But my lord, there is the interest not automatic, my lord. It has to be, my lord, for proceeding, my lord. Now he is admitting that he has no
Let us
jurisdiction.
see section 50. It's the interest on delayed payment.
But it has to be recovered for initiating proceeding, my lord, under section 73 or 74, my lord. 74 he has initiated and he has said, my lord, himself saying that there is no.
Will you show us 73, 74?
So may see, my lord.
This is for determination of tax.
Yes, my lord. Tax interest, my lord. In 74 subsection 1, my lord.
Only with regard to tax.
Now, my lord, section 50 is proviso lordship will see, my lord. It has to, my lord, if they want to recover something, they has to give a so cause notice. So cause they have given under section 74, my lord. Now they themselves saying that 74 there is no ingredient, my lord.
Company. Let me see it. Prima facie, there appears to be no
My lord,
infirmity.
lordship is section 74 can only be invoked, my lord, because section 75 is the section,
Oh, 74 years drop,
my lord.
but he has come to a conclusion that there was a delay in the payment. So therefore, under 50 years, invoke the interest on delayed payment.
73, my lord, it will come under section 73, my lord,
How?
because 50, your lordship,
Show
will
us.
well,
Show us.
50 is the charging section, not the proceeding, proceeding cannot be initiated under section 50, my lord,
You show us from a plain reading of 74 or 73.
my lord.
It is only with regard to tax.
Then, my lord, there has to be proceeding, my lord, section 50 is not.
Under what provision?
That is why, my lord, because for recovering, my lord, interest, my lord, there has to be a proceeding, my lord. It has to be under some provision, my lord.
That you have to find out and tell us what provision.
That is why so-called is to be required, my lord, for it, my lord.
Under what provision? Not under 73 or 74.
Lordship may see, my lord, section 50 proviso, my lord,
Yes, proviso.
to section 50, my lord.
Hmm.
Speaks of sections, proceeding of section 17 and 74, my lord.
No, no. You read it properly.
My lord.
Read it. Read it aloud.
My lord, provided that the interest on a tax payable in respect of supplies made during the tax period and declared in the return for said period furnished after the due date in accordance with the provision of section 39, except where such return is furnished after commencement of any proceeding. After commencement of any proceeding under section 73 or 74 or section 74A in respect of said period shall be payable on that portion of the tax which is paid by debiting the electronic cash ledger, my lord.
And what happens if it is after commencement of proceedings?
After commencement of proceeding, my if what the authority finds some tax is payable, it has to be paid along with interest, my lord.
Hmm. We'll examine it, but
Otherwise, the section 74, subsection 1, my lord, last part it speaks of interest, my lord.
Hmm?
Section 74, subsection 1, last part, my lord. Requiring to so as to why he should not pay the amount specified in the notice along with interest payable thereon under section 50 and a penalty equivalent to the tax specified in the notice, my lord.
I have not got it.
My lord, section, last part, may I read, my lord?
Last part of?
Well, I am reading the entire subsection 1, my lord, where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of facts to evade tax, he shall serve on the person chargeable with the tax which has not been so paid or which has short paid, or to whom the refund has been erroneously been made, or who has wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice along with the interest payable thereon under section 50 and a penalty equivalent to the tax specified in the notice, my lord.
Section 50 is independent of 74.
My lord, for recovering, my lord, section 50, my lord, because section, one has to take reports of section, either section 73 or 74, my lord. Proceeding has to be drawn under section either 74 or 73, my lord.
Show us some authorities on that.
Lordship may take up and reopen the judgments of the other high court, my lord.
Section 50 is independent.
Yes, my lord, it is charging section, my lord, but like my lord, section 39 is a charging section, my lord, review of tax and all, my lord, it is independent section. One has to pay under it, but.
Yes, Mr. Jain.
Lordship, this section 50 is independent, Lordship, because the tax has been paid after the proceedings has been started, Lordship. And moreover, in this matter, Lordship, the order on original has been passed and they have the option of alternative remedy. They can approach before the
He is
appellate
trying to
authority.
project that since you have already dropped the proceedings under 73,
74.
74,
Lordship.
there is no occasion for imposition of interest.
But Lordship, the delayed payment which he has made, thereafter that section 50 has been invoked. Because the taxes which has been paid, that has been paid after the proceedings started, Lordship.
All right, we'll keep it for motion hearing.
My lord.
Heard counsel for parties, that will be listed again on 19th,
My lord.
19th of January.
My lord.
For motion hearing. When the notices are not issued, the extra copies be furnished within the course of the day.
My lord. Much obliged, much.
The counsel for the petitioner has heard these states that since the proceedings initiated under section 74
For my lord.
was already dropped by the assessing officer, however, he continued to invoke the provisions of section 50 by imposing interest on delayed payments of tax. So Mr. Misra submits that this cannot be invoked without initiating a proceeding either under 73 or 74 of the CGST Act. And since the proceedings under section 74 has already been dropped, there is no scope for the assessing officer to impose interest under section 50 unilaterally. This again on 19th.
Much obliged. Let's not cancel some GST registration, my lord.
When was it cancelled?
Look, it was cancelled, my lord, in 2000 during the COVID period, my lord.
Then why are you coming now after 5 years? COVID is
Well,
long.
otherwise, my wrong is this, my lord, there is no proper
What
opportunity of hearing was given.
what is the point in coming for registration now? You have not been doing business for 5 years.
Now I'm revived, my lord, so I have
You have
come.
revived, you go for a fresh registration.
Lordship will see, my lord, otherwise this order, my lord, is passed without giving us opportunity of hearing, my lord.
Whatever it may be. But once your registration is gone, whatever you have done, you're not getting any credit for that.
Now, what I'm praying, my lord, if this is revived, my lord, department will not prejudice because I will be paying all the taxes and dues, my lord, till date, my lord.
You have no taxes to be paid except on the date when it was cancelled.
But if I have to file returns, my lord, I will be paying late fees and all till date, my lord. Department will not be prejudiced, my lord.
Yeah, after 5 years, what is the point for, why you have to explain why you come after 5 years?
But during the COVID pandemic, my lord,
COVID
no, I'm
is news now.
trying, but the business was his sustained loss, my lord, at that point of time. We could not revive the business. Now he is revived, my lord. And lordship, if this is revived, otherwise also if he will go for new registration, same formalities will be done. If it is revived, my lord, because
Therefore, we are saying go for new registration. Forget this one. It is 5 years old, it is gone. Go for new registration.
but my lord, if it is revived, my lord, it will not prejudice the department, my lord. There is no point of prejudice the department, my lord. The department will not prejudice, my lord.
Prejudicing the department will follow the procedure prescribed. It was cancelled in COVID, 5 years, 6 years. You have come now for revival without any explanation why 6 years have elapsed.
Because at that point of time, there's no business, my lord.
Where have you stated all that? And why suddenly you've got business now? How?
Because without GST, he cannot participate in tender process, my lord.
That's right. That's what we are saying.
But otherwise also, otherwise
So go for a fresh registration now.
in violation of the provision of the act, my lord. If I can show, my lord, there has to be a proper opportunity of hearing. Without giving a hearing, they cannot cancel it, my lord.
You go in appeal, you should have gone in appeal before the authority, higher authority.
Is in violation of principle and natural justice, my lord. That's why I have position.
After 6 years, you realize it's violation of principle and natural justice. No, they are not inclined.
Lord.
You're not inclined. After 6 years, what is this?
And at least lordship may observe, my lord, if I file and apply for new registration, but they will provide me, my lord. If the lordship may observe at least.
Of course, they'll provide you.
Lordship,
Because I
subject to
reject-
fulfillment of all the conditions.
What
for
conditions?
While making the application for GST registration, whatever procedure is there, if he fulfills it, then obviously lordship, he will get
It will always be fulfilled.
Or if-
Otherwise,
and lordship, he will get the new
If
registration.
they revoke it, my lord, if they revoke my lord's cancellation, my lord, even then, my lord, it will be same thing because I will be applying for a new one and they are revoking it, my lord. And my lord, one more thing, my lord,
what benefit do you get by revoking it?
because this registration number has been given to all the vendors with whom I am working, my lord. I have worked earlier. I have to
For 6 years, you did not get anything.
work, my lord.
Then 6 years, you did not get anything. Now suddenly you're getting some big business.
No, my lord, I am trying to revive, my lord. That's the only reason, my lord.
Yes, Mr. Chaudhary.
Lordship, delay is no explanation, proper explanation has
No
been given.
explanation. Why? What have you done for 6 years? Nothing is there.
In paragraph 7
You
only.
did
the
not file an appeal. You should have filed an appeal.
Yes, my lord. But your lordship, the lordship has passed those order where lordship has.
We have passed it, but I don't think we have passed anything beyond 2 years, 3 years. It is 6 years.
Lordship may take up on reopening again. There's judgment, but there are orders, my lord, which in past, my lord, beyond 3-4 years. There are orders are there, my lord.
Mhm.
There are certain orders are there, my lord. So wherein, my lord, the GST has been revoked, my lord, which will cancelled during COVID period, my lord.
We understand. COVID period is gone in 22.
Yes, my lord.
You file your affidavit,
Yes, ma'am.
additional affidavit explaining why the delay
My lord,
and why you want the revocation.
my lord.
Petitioner is permitted to file additional affidavits to explain the cause of delay in preferring the writ petition for revocation of the cancellation of the GST registration, which was cancelled during the COVID-19 period. And why, and further, and also, now let me stop. It is also seen that the petitioner has no explanation as to why no appeal as prescribed under the provisions of the Act as was also preferred. List again on
21st, my lord.
21st.
My lord. Much obliged.
Mr. B. Chaudhary for the respondent.
May be lost. Lordship, matter pertains to inaction of the on the part of the respondent number 4, where the petitioner filed an application under the provision of the Assam Compulsory Muslim Marriage and Divorce Registration Act 2024. Lordship, what the facts of the case is that the petitioner got married with the respondent number 5 in the year 2021. Thereafter, a few months, things were gone.
The divorce, according to you, is not been registered.
Yes, Lordship.
Lordship, I'll take the exception.
Lordship,
Heard.
Lordship, is in similar matter, Lordship, this coordinate branch of this court passed an order directing the authorities to act upon the application as follows. In this case, Lordship,
the divorce procedure were completed before during the continuance of the Assam Compulsory Muslim Marriage and Divorce Registration Act 1935. And at that time, the petitioner filed the application before the Register Qazi Lordship under that act Lordship. Thereafter, that act has been repealed by the government of Assam and passed this new act. And the
Have you gone through this order, Mr. Talukdar?
I have not.
Please go through the order.
Your Lordship. Lordship, para 13, Lordship.
Do you have a copy of the order? You've
Yes.
given it.
Yes, Lordship.
Let Mr. Talukdar go through the order.
Consider, this can be done
Yes.
in accordance with, this can be done in accordance with law.
As per section 12 of the Assam Compulsory Registration of Muslim Marriage and Divorce Act. But that is copy is there, Lordship.
If you want, you can go through it. We'll call it up after a while.
My lord, she has gone through it.
All right.
No, Lordship. Lordship, it is,
All right. Third counsel for parties, Mr. P.J. Talukdar, senior counsel assisted by Mr. Mehdi.
And for them.
Appears for 3 and 4, and G. Adhoikar appears for respondent number. You are appearing for respondent 1 and 2. Since the coordinate bench has already disposed of the petition, prayer is made for passing similar orders. Stop. The respondents do not object to the prayer made. In that view of the matter, the petition stands disposed of in terms of the following order. Right. Disposed.
Obliged.
If you.
May, Malada, I purchased a plot of land in a due procedure. My name was mutated. Then when it was cancelled, I went for a revenue appeal, remanded back after hearing, do whatever it is. But day after they have cancelled me, I sought for the order of that, the order for which they have cancelled me. I have applied for, but they are not giving me that order. That is why. Under the 2012 Act, that there is a provision for filing under the Right to Public Act under 2012, but that is regarding Jamabandi and other. But I want the order for cancellation. Why they have cancelled my, well, that order I want that. Extend to the order to. I request that order.
We'll issue notice here.
Only but let them have a opt-in instruction and
All
the.
right, Mr. Goswami. Mr. K. Roy Chaudhary, learned counsel appearing appears for the petitioner, Mr. N. Goswami, learned government advocate for the respondent. Petitioner is aggrieved that the order cancelling the name or deleting the name from the Jamabandi on 6/10/2025 has not been furnished. Although the petitioner filed applications on 31/10/2025 and
11 to
12.
11, 7, 11 to
7/11/2025. Being aggrieved, he has approached his court. Mr. Goswami is permitted to obtain instructions. Although notices are not issued, extra copies be furnished within the course of the day. Is the matter on 30? 30. Did issue notice on the last occasion?
Yes.
Do you have the number of the earlier matter?
Yes, Lordship.
What is the number?
7475 of 2025.
7475 of 25. Third council for parties should notice returning of 4 weeks. MSB Sharma, Leonard.
Respondent number one.
Respondent.
One. Others are by state.
State Council will represent 2, 3 and 4.
What is that?
Who's for industries?
Oh, Lordship.
Mr. N. Goswami appears for
16.
respondents 2, 3 and 4. Grievance of the petitioner is not non-release of what subsidy?
Right subsidy.
Freight subsidy, FREIGHT. Freight subsidy scheme. Under the freight subsidy, is non-release of freight subsidy under the freight subsidy scheme of 2013 for an amount of rupees 5,02,514 for the period 1/4/2017 to 30/06/2017. Notice, returnable so and so. List again after the returnable date, matter be listed along with WPC 7475 of 25.
So our name may be shown, Lordship, our name.
Names of all councils, including respondent councils, will reflect in the others list by the registry.
Much of it. Okay. Very well.
17.
Lordship, petitioner in this case is the chairman of the Manipur Samovar Samiti, Your Lordship. AGM for the year 2024-25, Your Lordship, was duly held, Your Lordship, as per the direction of the register, Your Lordship. But there was some delay, Your Lordship, in holding the AGM of 2025-26, Your Lordship, for which the petitioner, along with some board of directors, Your Lordship, submitted a petition for extension of time, Your Lordship. But the Assistant Register of Cooperative Society, Your Lordship, page 52 by order, Your Lordship. Page 52 may kindly page. Page 52, Your Lordship, holding that the AGM could not be held within the time 2024-25 AGM, Your Lordship, but already the AGM of 2024 has been held, and the proceeding has been duly approved, Your Lordship. But the AGM of 2025-26 could not be held, Your Lordship. But in the order, Your Lordship, application for seeking time for extension of time, Your Lordship, was rejected, holding that the AGM of 2024-25 could not be held in time, Your Lordship. Against this, Your Lordship, petitioner submitted an appeal, Your Lordship. Page 57, Your Lordship. But due to some defect in the filing the appeal, Your Lordship, petitioner submitted an application to withdraw the said appeal with liberty to file a fresh, Your Lordship. But that application has been rejected by the registrar, Your Lordship. Page 62, Your Lordship. Holding that the third paragraph may kindly be read. In this regard, the hearing was conducted on 8/12/2025 in the office of the chamber of the undersigned, which was attended by so-and-so, and Notbulution Losko, that is the petitioner has submitted a letter to withdraw his appeal petition. But the appeal was withdrawn with liberty to file a fresh, Your Lordship. May I kindly peruse page 61, Your Lordship. Is the application which the petitioner has submitted, Your Lordship. At this stage, Your Lordship, I'm praying for and liberty may be granted to file the appeal, Your Lordship, and time frame may be fixed to dispose of the same, Your Lordship.
Why did you want to withdraw the appeal? After
because-
hearing?
No, before hearing, Your Lordship, because some documents could not be annexed.
No. Hearing was conducted on 8/12/25.
In the
And then it is said, meanwhile, on the date of hearing, so and so submitted a letter for withdrawing.
because my application kindly peruse, Your Lordship, page 61.
Page
61.
61.
May I read the application, Your Lordship? With reference to the subject cited above, I have the honor to state that I preferred an appeal against the order dated 29/10/2020 passed by the Assistant Register of Cooperative Society, Hailakandi. Accordingly, by letter dated so issued by the Additional Register of Cooperative Societies, hearing has been scheduled to be held on 8/12/2025. However, while filing the appeal, there occurred some mistakes, not submitting the relevant document, for which I do not want to press the appeal in its present form, for which I want to
What
withdraw the appeal
documents?
with liberty to
What
file.
documents you did not enclose?
Because, Your Lordship, As per the Act, Your Lordship, Secretary, Secretary is to take necessary step for holding the AGM, Your Lordship, but Secretary and the departmental authorities could not submit the audit report, Your Lordship, in time, Your Lordship, for which the AGM could not be held, Your Lordship.
Isn't there a further provision for a review or appeal or something?
No. As per section 111,
For
registered
society.
appeal to be filed before the register, Your Lordship.
Before the registrar.
Before the register.
Lordship, I'll obtain instruction regarding this, your lordship.
What instructions?
Whether they have not been able to hold the AGM, your lordship, whether the board has been dissolved.
That is not his prayer. His prayer is that he wanted to withdraw. It was rejected.
My
and
prayer
it
is
was
very
dismissed.
limited, Your Lord. I may be allowed to file the appeal, annexing all the documents, Your Lord, for which, citing that reason for which the AGM could not be held, Your Lordship. 111, Your Lordship.
One.
There was a provision for filing an appeal to the state government and the question is. You call Mr. Talukdar. Where is Mr. Talukdar?
Lordship, he has some inconvenience today, lordship.
I heard learned counsel for the petitioner. This writ petition is directed against the order dated 12/12/2025. Passed by the registrar of cooperative societies. So who is the petitioner?
Chairman, Your Lordship, present.
The petitioner was elected as one of the board of directors of Monipu SS Limited. And subsequently the chairman of the society. So after taking over his charge of the chairman of the said society, he noticed several irregularities. And he demanded explanation from the person responsible. Stop. Is the case projected on behalf of the petitioner that since he has raised his voice against corruption and irregularities, he was removed as the chairman of the society by a resolution dated 8/3/2024 and from the post of director of the board of directors of the society.
Page 39, he was restored as chairman.
Subsequently, he was restored as chairman. Then against which order you filed the appeal?
Against 29/10/2000,
Annexure 12.
What is that order for?
it is passed by the assistant registrar for
For what purpose? For what effect?
Extending.
for extending the time to hold AGM.
Subsequently, an order was passed on 29/10/2025 by the in-charge Assistant Registrar of Cooperative Societies, extending the time for holding the AGM. Stop being agreed, the petitioner filed an appeal under section 111 of the Assam Cooperative Societies Act 2007. His appeal was filed before the Registrar of Cooperative Societies. Stop. The petitioner prayed for exemption of disqualification to participate in the next election/AGM for the society, the constitution of the new board in Manipur's CS Hailakandi. Stop. The matter was fixed for hearing on 8/12/2025. Stop. On the same date, the petitioner submitted a letter seeking withdrawal of the appeal petition. However, the Registrar of Cooperative Societies rejected the prayer and rejected his prayer for withdrawal of the appeal and also rejected the petition filed by the appeal petition filed by the petitioner for allowing him and other POD members to participate in the next election/AGM of the society. The petitioner, being agreed by the said order, is before this court. At this stage, the court is not inclined to issue notice. However, the court considers it appropriate to permit the standing counsel representing the cooperative societies to complete her instructions in the matter placed on 28th of January. Give extra copies.
Your Lordship, they're going to hold the election, Your Lordship, till
When?
very soon, maybe.
Give a date. List on 21st.
Oblige.
Yes.
Oblige, Your Lordship.
This is a matter for cancellation of invitation and delaying in the once cancellation. Delaying the.
Yes.
Hello. Petitioner 1 to 9 are the possessor and owner of a plot of land, tag number 234 and patta number 383.
You want to sell your land,
Yes,
NOC not granted.
not granted. Due to some, they are.
Some corrections is also taking Lordship. It's some correction of the errors and the mutation. The record of rights.
You get instructions here.
Lordship. Lordship.
My lord, we have already, when we have intended to sell the plot of land, we have encountered that there are some minor errors that might be administrative errors and the mismatch of the name. It is not mismatch exactly. Earlier, what happened, the nicknames, some nicknames were inserted there and it is already there. We thought that prior to proceeding to the sale, that should be corrected. So accordingly, we have applied for the necessary correction, which is yet not done. And it is almost, it is accepted. It was accepted by the office, but they are not intending to do the necessary correction without any legitimate ground, valid ground, because it was a vernacular error, Dunnodhar. It was written as Dunno. That we have given the proof also.
Let him get instructions. here.
Yes, every time they are denying. And we are suffering for this. It is a matter of almost 1 year.
We learned common advocate will have taken instructions as to why the petitioner's application seeking correction of the particulars in the land records in respect of the landowners have not been permitted by the revenue authorities. Although the applications filed have been accepted by the which officer? Circle officer.
Circle officer. Your Honor, there is another problem. That petitioner number 629 already gave it a recorded patta there, because we have two plots of land, two dags there in a single patta, that we have sold out a plot quantum of 5.5 lesa out of that 1.5 katha. So it was an error in the office record. Instead of striking out the name of the father, they have struck out all the names of the pattadar. So again, we need that mutation there.
Instruction here.
But
You served, you furnish extra copies of the writ petition.
Yes,
Can you do it today?
on Monday.
Monday,
On the
holiday.
Monday.
You do it
Day.
after, within 10 days from today.
Okay.
That will be listed on 4th of February. 4th February.
I need to apologize for yesterday, appeared for item number 9 and I could not come in time. I need to apologize for that purpose. Yesterday. Here in this case, Your Lordship, this is a case I'm challenging the order dated 15/10/2025 by the land records assistant by the South Salmara at Pace, Your Lordship, in annexer 33. 33, I have issued notice, thereafter Deputy Commissioner has done nothing. And fraudulent activities by the respondent number 5. And the same potter, same dog on the two plots, in the same plot of land.
Third council for parties issue notice.
I am appearing for respondent number 5 here.
Mr. N. Goswami.
Or
Station
2, 3 and 4.
appears for respondents 1 to 4. Mr. You are appearing for?
2, 3 and 4.
E. Hazarika for 1, N. Goswami for 2, 3 and 4. Mr.
I am M. Hassan, Your Lordship.
M. Hassan for respondent number 5 and 6.
Only 5.
Only 5. Therefore, notices in respect of respondents 1 to 5 are waived. However, extra copies be furnished within a period of 2 weeks. Steps on respondent 6 by a registered post as well as usual course within 2 weeks. Matter be listed after the returnable date.
Deep level. My lord, it relates to the ex parte award of the permanent Lukadal law. It's a second round of litigation, Lordship. First litigation, first time, Lordship, page 54. The same case, Lordship, it was stayed by this honorable court. Decree, execution of decree, and remanded back by the judgment, Lordship, page 69. And then thereafter, Lordship, it was again the file was open and passed an ex parte award, for which, Lordship, it was sent as per Legal Service Authority Act, Lordship, it was sent for execution of the decree. While it was sent for execution of the decree, Lordship, the learned trial judge, Lordship, passed an order, Lordship, to freeze all the bank's accounts of the particular Gao Panchayat, Lordship, for which the people are suffering, Lordship. And
all the salaries and everything, Lordship. So at this stage, Lordship, may I pray, Lordship, let notice may go to the respondent, Lordship, and in the meantime, Lordship, the further proceeding of the money execution case, Lordship, may be state page 54 or earlier was the same order, Lordship, was there, Lordship. Page 54 may kindly please. Same case, Lordship, same or
Who filed the earlier case?
earlier case, same party, Lordship.
Then
No, Lordship, the earlier case was filed by, before the Legal Service Authority, Lordship, by the sum of the
we
beneficiaries.
issue notice here, heard counsel.
And execution may be stayed, Lordship, otherwise.
Mr.
All the respondent, I'll take steps by registered. form.
This is filed under 226 or 227.
It can be, Lordship, may be treated 227
No,
also,
no question of treating it.
Lordship.
It depends on how
226.
you want to file it.
Lordship, it may be 227, Lordship.
No, not maybe.
Lordship, kindly consider that because the stay order, Lordship,
No, you can't get a stay order like that.
Lordship. Lordship, the earlier judgment also, Lordship, the same, Lordship, things was, observation was there, Lordship. May I, Lordship, page 69, Lordship. May I kindly peruse first last line, Lordship, paragraph, first paragraph. There was a reference of Honorable Apex Court judgment, Lordship. If, may I read, Lordship, page 69, first paragraph, last 3 line, Lordship, 3-4 line. If a party to the dispute in with a grievance against an award, so it can approach the High Court under the supervisory extraordinary under Article 226 and 227, Lordship.
They're reading from which judgment?
Page 69. Of my read petition, Lordship. Page 69. Lordship got it. It will. First paragraph, middle portion. It is held by the Supreme Court Bar Council of India so and so. After a detailed consideration of the provision contained in so and so, if a party to a dispute has a grievance against the award or permanent, it can be approached the High Court under its supervisory and extraordinary duty under Article 226 and 227 of the Constitution of India. So kindly consider that, Lordship, people are suffering of the particular Gao Panchayat because entire bank accounts are freeze, Lordship, for which by virtue of
When was the order passed?
that award, Lordship. Award execution order was passed, Lordship, 116/8/25, Lordship. Then thereafter subsequently operative portion of the order, page 81, Lordship. In the money title execution decree number 3 of 2014, which was earlier stated by this honorable court, and after hearing the entire matter, set aside the said award and remanded back to hear both the sides, Lordship. But subsequently, Lordship, it's only a public money is involved, Lordship. It was the incidence of 2006 and 7, Lordship, regarding the MG and Rega money without any works, Lordship. And officers are changing, Lordship, for which, and the learned trial court, Lordship, passed this order, suffering the peoples of that particular Gao Panchayat, Lordship, because the entire bank accounts and everything was freezed by virtue of the order in the execution case of 3 of 2014. Same way, Lordship, earlier also, which I referred in page 54, this honorable court in the same.
Learned counsel for the petitioner. This writ petition is directed against the ex parte award order dated 2/9/2023, passed by the chairman, District Legal Services Authority, Achar Silchar in PLA case number 01 of 2022. On the basis of the ex parte award, the money execution, within bracket, transfer decree, bracket close, case number 3 of 2014 was initiated before the learned civil judge, senior division number 2, Silchar, Achar Silchar, whereby the learned judge attached the bank accounts of Sonapur GP and issued the bailable warrant of arrest against the official respondents. So it is the submission of the counsel to the petitioner that because of the attachment of the bank account, the entire development works and salary of the Jal Jeevan Mission water supply employees and such a Bharat worker will not get their salaries or remuneration. It is further submitted that the above order or award was passed by violating the provisions of section 22 capital C within bracket 1, within bracket 4, within bracket 5, within bracket 6, and within bracket 7, the Legal Services Authority Act 1987. Stop. Therefore, the petitioner being agreed as approached this court for setting aside and quashing the ex parte order until final disposal of the above matter. And for adequate interim orders, staying the further proceedings of the money execution transfer decree case number 3 of 2014, arising out of PLA case number 01 of 2022, pending before the Civil Judge Senior Division number 2, Achar Silchar, and with a further direction to the court to defreeze the accounts of the above Sonapur. What is that? Sonapur?
Sonapur GP Gao Panchayat Lordship.
Sonapur GP Gao Panchayat. Stop. Counsel for the petitioner has also referred to orders passed by coordinate benches in WPC number 462 of 2019, dated 5/3/2020, and the judgment of the apex court rendered in Bar Council of India versus Union of India, reported in 2012, 8 SCC 243. Wherein it is provided that if a party to a dispute has a demands against the award of the permanent Lok Adalat, you can approach the High Court under its supervisory and extraordinary jurisdiction in the Article 226 and 227 of the Constitution of India. Accordingly, issue notice returnable 4 weeks. Steps of the respondents by registered post as well as usual course within. You don't even have the addresses. How will you take steps?
Lordship, will take
Not
steps.
reflected here.
Lordship, address is their lordship. Will earlier also registered post by registered post I take it. Little bit time may be given for that, lordship.
But we'll not grant you an interim unless we are only issuing notice on the interim.
Lordship, but till then, lordship, at least the accounts, lordship, because earlier occasion also page.
Steps on the respondents by registered post as well as usual course within 3 weeks from today.
Or dusty service may be, lordship.
Notice.
I may be allowed.
The way of dusty is also permitted, provided the same is routed through the office of the, routed through the registry of this court. And an affidavit of compliance is filed before this court. Issue notice on the interim prep. Returnable on 6th of February.
Lordship, I pray till then, lordship, at
The
least.
next date fixed, the award passed by the Permanent Lok Adalat shall not be given effect to.
And execution of the, it is now on process of execution, for which
The execution case number so and so.
may not be given effect to till next returnable date, lordship.
Yes.
Much obliged, lordship.
Please, Your Lordship. The petition arises out of a workman compensation case, my lord, where the trial has concluded and the written arguments have been filed, my lord, and the matter was reserved for judgment. The judgment has not been pronounced for a long time, Your Lordship. Your Lordship will come to page 107. 107. The order dated 14/12/2023. Both the parties filed written argument today. This is the claimant side and the insurance company. Hence, the case is reserved for judgment. This is on 14/12/2023, man. And thereafter, my lord, the matter has been kept separately for judgment, but no judgment has been pronounced by the respondent number 3 till date, my lord. Many times the petitioners have approached the commissioner, my lord, personally, praying that judgment may be given because they are very poor people, my lord. And they are sure that it will be given after 1 month, 2 months, and the matter has been going on in that manner, my lord.
Which authority is this?
Assistant Labour Commissioner, my lord, Kamrup Metro.
Mr. Goswami?
I'll take notice. 123.
Petitioners are agreed that in spite of the hearing being concluded in respect of work WC case number 148 of 2010 before the Commissioner of Workmen's Compensation Ulubari Committee, and the matter having been reserved for judgment as far back as 14/12/2023, the judgment has not yet been delivered. Stop. Left with no alternative, the petitioner is before this court. There are Mr. N. Goswami, learned carbon advocate,
123.
appearing for
123.
respondents 1, 2, and 3. Submits that he will obtain instructions on the matter. Although notices are not issued, extra copies will be furnished within 1 week from today. List the matter on 30 January.
Highly obliged.
Please, January.
January.
Highly obliged.
Right, please, my lord. Lordship, the petitioner is a small-time businessman involved in selling and buying of broiler chickens. On 25th of November, he came to know that his account has been frozen, which was operative since 2022. And since thereafter, for the last 1.5 months, he has been running. And on inquiry, he has been informed, which is on page number 23. This is a piece of paper given to him by the bank, page 23. That 796 rupees in his account came from some fraudulent sources or whatever we could not find in our own account statement, and therefore our whole account currently having 6.5 lakh rupees is frozen. So in similar situation, this court has given relief. And that order also I have placed here in page 27. So similar relief I am seeking, that the disputed amount, if at all, may be kept on lien, and I may be allowed to operate the rest of the account and use the rest of my money.
Yes.
Lordship, I need to take the instruction, Lordship, from the bank.
Come back on the reopening day,
Yes, Lordship.
19th. Please take it on 19th, enabling the respondent counsel to complete the instructions. Although notices are not issued, extra copies be furnished within the course of the day. Obliged.
Much obliged, Lordship.
That is the lordship matter. They said, if I'm selling the judgment, is it 10/9/2020 passed by the London Board of Revenue, cancelling my mutation matter. This was purchased in 1981 at purchase. Now I am contemplating to file civil suit. Ultimately, it will be decided in the civil court. But I have to challenge this order, my lord. Otherwise, this order will remain against me. The order is required.
What is the finding?
Finding, my lord, that I could not prove the same, my lord, because ADC is, after verifying all the documents, recorded my name, my lord. But London Board of Revenue, that I could not produce the sale deed. Admittedly, my lord, my sale deed has been damaged, my lord, due to, my lord, a lot of things, my lord.
No, what is the
Damage, my lord. That is quite invisible. It is a matter of fact.
What is the finding of the revenue board?
Yes, finding of the revenue board, because of this, my lord, document, I could not, that documents quite, the sale deed could not be properly read, my lord. But that sale deed I have there, my lord. I have leave of this honorable court to show you, my lord. Page 28, my lord. Last page. Basically, my lord, my sale deed I could not.
Appeal filed by?
Appeal filed by the respondent, my lord, private respondent. Challenging my mutation, my lord.
Heard Mr. A. Chaudhary, learned counsel for the petition. Issue notice. 2 weeks. It's Roy. MSPR Monto for responding 1, Mr. S. Roy for respondents 2, 3, and 4. So since the respondents 1 to 4 are represented, notices were waived, extra copies shall be furnished within a period of 1 week from today. Steps on respondents 5 to 9 by registered post as well as usual course. That the records of appeal 17, 16, sorry.
96 are in. 96.
96 RA within bracket K of 2019 be called for on the Assam Board of Revenue. Meanwhile, no consequential steps be taken in terms of the directions contained in the judgment and order dated
10-9.
10/9/2024, passed by the Revenue Board in so and so.
Problem.
Until further orders.
24.
May your lordship please, my lord, the petitioner are the owner of respective plot of land. My lord, what happened, respondent, they constructed the gas pipeline over their land, my lord. And the no notice, nothing, my lord, no compensation, nothing was given, my lord. This is my case, my lord. They have to follow the provision of the Petroleum and Mineral Gas Pipeline Acquisition of the Right of the User in Land Act 1962. The 62 Act, PMP Act, 62 has to be followed. But that act has not been followed. And they have not issued any notice, nothing, my lord.
Third counsel for party issued notice. Taken over 4 weeks, Mr.
I'm for
Justice
1, 2, and
APS
3.
for
1 and 2.
1 and 2. The full notices are waived, extra copies we furnished within a period of 1 week from today. Steps and respondents. 3, 4, 5. 5 registered post as well as usual posts. That will be listed again after the return of the date.
25.
And appears. The petitioner on the matter is called up, Mr. S.S. Roy, appears for
2, 3, and 4.
3 and 4, placed after a week. MSPR Mondo for 1.
26.
Wait, please. The matter pertains to eviction from railway quarters, my lord. The petitioner and a widowed mother is sought to be evicted without following the due process laid down in the 1971 Act, my lord. In fact, essential supplies like water and electricity has been disconnected to coerce and harass them to.
You are not employees of the.
No, I am the daughter of the deceased railway servant, my lord. But in any case, my lord, 71 Act has to be followed, my lord, for any kind of eviction. Because otherwise the entire action would be without jurisdiction. There's an estate officer who shall initiate. There's the provision of a show cause notice, then a hearing, thereafter the provision of appeal, my lord. And the deepest
Does
aspect,
it
my lord.
include an office quarter?
My lord.
Does it include the office?
Yes, public premises would include a railway quarter, my lord. Under section 2E of the Act, my lord. The public premises, eviction of unauthorized occupants, my lord. That is more or less admitted, my lord. That has to be followed, my lord. There are estate officers of the railway department, railway, my lord.
Which provision?
My lord, section 2E, definition, my lord, which defines a public premises. 2E1 would cover a railway quarter, my lord. 1.
E1.
1. Any premises belonging or taken to, on lease or requisition by, on behalf of the central government, and includes any such premises which have been placed by that government, whether before or after the commencement of the public premises, so and so forth. And if my lord comes to section 4, my lords, there is a elaborate procedure, my lords, for eviction, which has to proceed with a show cause notice. And thereafter section 5, eviction, my lords, and thereafter section 9, my lords, which provides for appeal, my lords. And if my lord.
But is there any entitlement on your part?
My lords?
Is there any entitlement?
Yes, my lords. I may be an illegal occupant, my lords, or an unauthorized occupant, my lords. But for eviction of an unauthorized occupant, my lords, a specific mode has been prescribed by law, my lords. That has not been adopted. That's the only way a person can be evicted from a public premises, my lords. And in fact, my lords, my lord may kindly come to page,
But for you, 3B would be applicable, I think.
my lords,
3B,
3B.
3 capital B.
3 capital A is there, my lord. The 3 capital B of
3 capital B.
the 71 Act, my lords.
Yes.
Yeah.
Inserted in 2019.
Oh, I'm so sorry, my lord. This act is of 2018. The publishing of this is of 2018. No. I have it, my lord.
Yes, Mr. Gupta.
So since eviction has already taken place, my lord, I have to take instruction whether that procedure which has been alleged not been
You're
followed.
already out.
No, I'm not out, my lord. My lord, that's why my lord may come to page, my lord, page 102 for a moment, my lord. Essential supplies has been disconnected, my lord, which is against the dictum of the Supreme Court, my lord. It violates Article 21, my lord. Page 102. On 16, they disconnected water. On page 103, my lords, if my lord comes to page 16 December, they disconnected the water supply. And on 18th, my lords, they disconnected the electricity supply. My lord would see page 103. It's a seizure by the junior engineer, my lords. He came to the premises randomly and he disconnected the ceiling fan, the meter, smart meter, LED tube light, my lord. That is, my lord, that cannot be done, my lord. They're trying to coerce the petitioner to evict without following the due process of law, my lord.
Yet
Well, can it be taken up at 2, my lord? I'll take instruction whether they have been evicted or not.
Not evicted, not evicted. So my
Because
only prayer now, my lords, that
prayer
they have
is,
to
my
follow
lord-
the due process of law, my lords, and in the meantime, the essential supplies has to be restored, my lord.
all seized items or
She
also
lives with her
they have
widowed
paid-
mother, my lord, in the quarter.
No, but as per 3B, I think notice is sufficient.
No, my lord, there's no notice at all. There's no notice, my lord. If I can have a look.
their contention, my lord, I'll have to take instruction on that. My lord will take up at 2 p.m., my lord, I will take. My lord will take up at 2, my lord, I will take instruction whether proper notice was issued on, because it is their contention that notice.
No,
has not been-
instructions as such will not help. You'll have to show us some material that yes, it was fixed on so and so date. They
I'll get it,
responded
my
to
lord.
the-
My lord will fix it at 2, my lord, I will get the instruction.
My lord may take it up immediately after the vacations, my lord. Till then, my lord, no coercive action should be
No,
taken.
that fact that the eviction has taken place or not, that also, my lord, I have to.
All right, let me get your instructions. At 2 p.m.
2 p.m.
My senior is left at in court number 4.
Huh?
My senior is court number 4.
Ah.
Time is.
At 2 p.m.
28.
Please, Your Lordship. This matter relates to cancellation of the GST registration of the petitioner's lordship. The reason for cancellation of the registration is because we had not furnished the bank details to the authorities, lordship. However, lordship, we have not been undertaking many business activities, lordship. So that is the primary reason why we were not following up with the authorities. In any case, lordship, we have filed the pending returns till the date of cancellation. And lordship, we are praying that this honorable court may direct the restoration of the GST registration. We'll pay all the dues, lordship, that are paid.
Lordship, may kindly peruse Rule 21D, Lordship.
GST. 21.
D, Lordship, clause B. Registration to be cancelled in certain cases, Lordship. The registration granted to a person is liable to be cancelled if the said person violates
What rule?
GST rules 2017.
2017 GST rules.
CGST,
Yes.
Rule 21, yes.
21D, Lordship says, if he violates the provision of Rule 10A, and Rule 10A, Lordship,
Furnishing of bank account.
bank account within 30 days of giving of the certificate of registration.
So why bank account was not given?
Because we are not undertaking much activities, Lordship. So that was a error on our part, Lordship. But now we are ready to comply with all the.
To go for a fresh registration. You have not done any business, how, what difference does it make?
We have done some business, but not many business, Lordship. So payables also will not receive now, Lordship.
And then?
There are multiple orders where this honorable court has allowed, Lordship.
Allowed, but it should not be taken beyond the permissible limit. You are not in business, you did not submit a bank
We have
account.
done some business, not that we have not done any business, Lordship.
Yeah.
But whatever is payable to us will not be paid, Lordship, unless we have the GST registration, because this was against a different registration.
You get a GST registration and submit them the new number saying that we are new registration is this. All payments are to be
No, we
allotted.
cannot do that, Lordship, because input tax credit questions are there, because initially there would be a different registration that they are doing business with. And now there cannot be a different registration, because then they will not get the input tax credit. That issues are there, Lordship. That is why we are paying for restoration. Otherwise, we could also go for fresh registration, but that will not suffice.
What is the
That is
input tax credit? Can you find out?
That, Lordship, only on the basis of the return and everything that. And since from the pleading in the appears that till September 2025, not any sort of big business loss, only on 2025, when the CA looked into the website, then only they came to know. That's the reason, Lordship. And 10A, Lordship.
Have you filed your return?
Yes, yes.
Where?
Annex one of the returns, Lordship.
You annex all your returns.
I can
Let us
furnish
see
a
what
copy.
is your turnover, how much of input tax credit are you likely to get if you
Not
claim?
us, Lordship, the person who does business with us. Not us, because we are others who will do business with us, they will
That's
also
right.
avail the credit.
You want to avail of the ITC?
Not us, Lordship, because somebody who will pay to us, if we are receiving something from
Why
somebody.
are you concerned with somebody else?
No, because we have to receive money from them.
So where are the returns? To
I have
show that
annexed
what is
one,
the
I have
amount?
made a statement, Lordship. I have annexed of the period December 2023-24, Lordship, page 28.
20?
Page 28, Lordship. This is basically a zero return, Lordship.
Then zero return means you did not.
Oh, business, Lordship.
There's no taxable value. Then why do you say that?
So there is some, if Lordship wants, I can furnish the details of the business that we did. But I'm just praying, Lordship, because they will anyway for restoration, Rule 22 would have to be complied with.
We understand everything. What we don't understand is if you have not done a business, why are you asking for restoration
done some
instead of not
business.
going
I
for
will-
a fresh?
I will furnish the details of
You
those.
furnish
business,
it.
Lordship.
You furnish it here. You have to satisfy us. Counsel for petitioner will file additional affidavit to bring on record to substantiate their claim that some amount of business was undertaken by the petitioner prior to the registration being cancelled by the GST authorities. At least after 2 weeks. You give him extra copies.
Lordship, may I kindly fix the date after the video? File it by-
30.
Lordship. Much obliged.
January.
29.
Met leader also.
Here in this case, petitioner was declared as elected member of 8 Nong Ward, Garojan constituency, Lordship. And thereafter, another contesting candidate, Lordship, he filed one election petition that your Lordship will find at page 42. He filed this under section 127 instead of 129, Lordship, that page 42. And after filing of this case, Lordship, that respondents appear, including the present petitioner, Lordship, they filed their WS, all everything was on record, Lordship, that I have annexed subsequently. Now, Lordship may kindly turn to page 59. This is the written objection filed by the present petitioner, Lordship, raising some preliminary objections. Page 59. And during pendency of thereafter, Lordship, the matter was fixed. Lordship will kindly now turn to page 66, Lordship. Page 66. So after hearing all such, Lordship, the matter was fixed on 27/10/2025 for further hearing, submission of evidence in chief on affidavit, Lordship. Now, this matter was fixed on 27/10/25. Now, next page, your Lordship will find 27/10/25. On this date, Lordship, that petitioner was absent, so it ought to have been rejected, but dismissed. But the respondent side file application for preparing for adjourning the case, Lordship. So it was adjourned and fixed on 20/11/25. Now on 20/11/25, Lordship, it is only reflected that both sides represented, heard both sides. Now the matter is fixed on 9/12/25 for orders. And on 9/5/25, that is it, page 69, the court found that that issues are not framed yet. So issues were framed, Lordship. And the matter was fixed on 23/12/25. And now I'm aggrieved by this 2012/2025 order, Lordship. By this order, interim order was passed directing the district commissioner to submit all the ballot papers before the court for recounting, Lordship. Without there being any evidence, without there being any other materials, Lordship, as an interim measure, this order was passed on a prima facie basis on the pleadings of the contesting candidate, Lordship. And our High Court has already held that in an election petition, Lordship, that election tribunal do not have any power to pass any interim order, Lordship. And they derive their power only from that notification, Lordship, that I have annexed, that page 28, Lordship will find. This notification was issued by the government of Assam, Lordship, under section 127 of Assam Panchayat Act, constituting the election tribunals, and their jurisdiction and power, your Lordship will find at page 30.
Yes.
Page 30, powers. The Panchayat Election Tribunal shall, for the purpose of disposal of the election petition mentioned here in before, shall have all the powers of a civil court for the trial of a suit under the Code of Civil Procedure in respect of the following matters. So they will have the power in respect of these matters which are mentioned here. Summoning and enforcing of the attendance of any person and examining him on oath, requiring the discovery and production of documents, receiving evidence on affidavit, requisitioning any public record or copy thereof from any court or office, and issuing commissions for examination of witnesses or documents. Now, next, your Lordship will find procedure to be followed by tribunal. The application to be filed under section 129, but I have already placed for you that the application was filed under 127, Lordship. Shall be in the form of a memorandum. So that part, now Lordship may kindly turn to clause 4. The tribunal shall hear the parties, examine such witnesses as may be adduced. So that was fixed, but that was not done, Lordship. Examine such documents as may be produced by the parties or obtained by the tribunal. And after hearing, the tribunal shall pass such order as it may deem fit with reasons thereof. So what my understanding and that this coordinate bench judgment is there, explaining this clause, Lordship, that tribunal have no power to pass any interim order.
Where is that coordinate bench?
Lordship, just a placing that.
WC 402625.
Provisions were discussed from 23 onwards. Lordship may kindly page 26, 27, and 28. And 33 important Lordship.
20?
26, 27, and 28.
Any appeal against this order?
No, it was not filed. Lordship.
And what is the judgment of the apex court that you are including?
That apex court judgment, Lordship, I'm just placing another judgment, Lordship, of apex court. Three to keep that. 2003 1 SCC, Lordship, may kindly have a look at paragraph 20 and 21. Exactly on my case, Lordship. 2003 1 SCC.
Paragraph?
390. Paragraph 20 and 21.
Yes.
May I As seen from the decided cases mentioned above, in election petitions which are filed with prayer for recount of votes, the court has always insisted upon a high standard of proof of grounds as would impel the court to direct recount of votes and recheck the election results. It is only after the election petitioner is able to demonstrate before the court by leading satisfactory evidence that there was serious flaw in the counting procedure which had mechanically affected the result of election that the prayer for recounting is generally allowed. In such a state of election law, the court legitimately expects the parties to approach it with genuine grievances on truthful facts, where false facts are pleaded and false evidence is produced to mislead the court into interfering with the people's verdict of election. The misconduct of the parties to the election has to be viewed seriously. The court allows an election petition only on strict proof of one of the grounds prescribed in section 100 of the Act. If the parties to the election petitions are allowed to take the court lightly, even though attempts are skillfully made by them by false pleas and evidence to mislead the court, the whole judicial process would be misused by clever parties to their advantage and to the detriment of the
This is a general principle.
general principle.
But
And
what
here
about
also, Lordship,
regarding interim orders, is there any other judgment that you're referring to?
no, that coordinate bench judgment, Lordship, regarding intent. Because that is not challenged in the appeal, Lordship.
You might heard. Mr. A. Amit, learned counsel group. And Mr. S.S. Roy, learned government advocate.
1, 2, and 1, 2, 3, and 4.
1, 2, 3, and 4.
Lordship.
The petitioner before this court is aggrieved by the order.
Page 70. 23, 12, 20.
23/12/2025 passed in this election case number 01/2025. Whereby Election Tribunal directed the District Commissioner of Gwalpara to produce the ballot papers of the election of GP member for unit number 8 of Garojan within bracket or KA bracket close Simlabari GP before the court under sealed trunks to facilitate this court for recounting of votes on or before the next date. Stop. The next date in the matter is fixed on 19/1/2026. The case presented before this court by the petitioner is that the petitioner was elected as a GP member,
Ward member.
of which
Garojan or constituency.
Garojan constituency of Simlabari GP.
And number 2, Simlabari.
Number 2, Simlabari GP. Stop. The election of the petition was challenged by the private respondent by filing petition before the election tribunal under section 127. Stop. It is in these proceedings that the impugned order dated 23/12/2025 was passed by the election tribunal. The learned counsel for the petitioner submits that their perusal of the order reflects that there is no material or evidence discussed by the tribunal before issuing an interim direction. Before issuing a direction in the interim to the district commissioner, the district commissioner Gwalpara to produce the ballot papers. Stop. It is submitted that the basic challenge made in the election petition is the election of the writ petitioner by improper reception. It must be improper reception.
He's in the petition, he said, Lordship, that there was miscalculation and the votes which were given to me ought to have been given to him, Lordship.
So improper reception and miscalculation of the ballots. Which has resulted in the election of the writ petitioner. Under such circumstances, it was incumbent on the election tribunal to at least add prima facie materials and evidence before the court, before the tribunal, to arrive at a finding to issue such directions as have been done by the impugned order. So, the further contention of the learned counsel to the petitioner is that the impugned order is bad on another count, inasmuch as by the impugned order, the tribunal had directed the district commissioner Gwalpara to produce the ballot papers in sealed trunks by way of an interim order. Stop. Referring to the judgment dated 23/7/2025, passed in WPC 4026 of 25. Passed by a coordinate bench of this court, learned counsel submits that para 26 of the judgment, the coordinate bench has returned categorical finding that none of the provisions of the Assam Panchayat Act 1994 read with the notification. This is the same notification?
Yes, this is the same
notification dated 3009/2000, instituting the election tribunal, revealed that the Panchayat election tribunals have been conferred with powers, pass interim orders, stop. Correct. He has also referred to a judgment of the apex court rendered in Inder Pratap versus so-and-so reported in 2003 1 SCC 390 to support his contention that before any directions are issued, the tribunal must adopt a high standard of proof. The tribunal must insist on a high standard of proof of grounds to direct recount of votes or rechecking of election results. He therefore submits that this order, being contrary to the provisions of the Assam Panchayat Act 1994 as amended, as also the ratios laid down in so-and-so judgments, the impugned order, bad in law, and the same should therefore be interfered with as prayed for. And pending further proceedings, the adequate interim orders be granted. Well, Mr. S.S. Roy, learned government advocate, submits that as on date he has no instructions, he would like to complete his instruction. Having heard counsel for the parties and upon careful perusal of the writ petition along with the enclosures, as also the judgments pressed into service and the provisions of the Assam Panchayat Raj Act, read with the notification number so-and-so. The precise question before this court is whether the election tribunal is empowered to issue an interim order in any election proceedings to the effect as has been done by the impugned order dated so-and-so. The judgment pressed into service of the coordinate bench had returned a finding that election tribunals do not have powers to pass interim orders was essentially on facts where interim orders were passed restraining the returned candidate from assuming office or staying the election of the returned candidate. So, such is not the circumstances in the present proceedings. The question, the challenge before the election tribunal is improper reception and wrong counting of the ballots, leading to the petitioner being returned in the ensuing elections. Be it as it may, since the question has been raised before this court, the matter will require hearing. Therefore, at this stage, let notice issue, returnable 4 weeks. Since Mr. Roy accepts notice on behalf of respondents 1, 2, 3, and 4, notices were waived, extra copies we furnish. Steps on respondent 5 by registered post as well as usual course. Stop. Service of notice be effected by way of dusty also routed through the registry of the court, and an affidavit of compliance be filed before this court. As per the impugned order dated so-and-so, the next date of this, the matter is fixed. Production of the ballots on 19/1/2025. 2026. 23/12. 23/12. Under such circumstances, to returnable, very good, 4 weeks no more. We are giving it returnable 2 weeks. Take steps immediately. Let the matter be listed again on 30 January. Till the next date, next. Further proceeding with election tribunal so and so shall remain stay. The continuation of the interim order will be reconsidered in the next date fixed. Please accordingly.
Obliged.
And they're supposed to open instructions, my lord.
My lord, our instructions are awaited in this matter, my lord. We prove progressing.
Similar orders are fast.
Yes, my lord.
But when it comes in for copies. Similar order.
Man.
Much amazing. Please.
Petition is regarding indication of the land matter. The scheduled land minor is a sweet land over which our predecessors have right title interest in possession by virtue of a judgment and order dated 6/8/2015 in title appeal. So that particular scheduled land was decided in our favor. Thereafter, my lord, there was no second appeal to that petition, so there was execution petition from our side. The execution was also decided in our favor. Later on, my lord, our predecessors died, and thereafter we filed RTPGS, my lord, online for the mutation of that land in our name. That remains pending, my lord, till date. And after that, my lord, we filed application before the additional district commissioner on 16/7/2025. That also remained. On that application, my lord, there is an order, my lord. Lord, so will kindly come to page number 48. That is the order, my lord, based on the application. And by this order, my lord, the ADC, Additional District Commissioner, has already ordered the circle officer to take necessary action in course of this title execution and title appeal, as well as our application. So this order, my lord, the circle officer has kept it in pending despite this order of circle.
Yes. Please take instruction with regard to page 48. Okay. Third council for copies, Mr. S.S. Roy, from the cabinet will obtain instruction as to by the circle officer for revenue circle. Yes. As to the status of any orders being passed by the circle officer, Chapo Revenue Circle, on the prayer made by the petitioner. Regarding the mutation of the name of the decree holder. So. The additional district commissioner, we have also instructed, also directed circle officer, Chapter Revenue Circle by communication dated 23/7/2025 to take necessary action in terms of the court's order or decree passed earlier and as per rule and submit a compliant report. So. You furnish extra copies.
It may be fixed, my lord. Actually, this particular land is to be acquired by the APDCL. They have proposed to acquire this land, my lord.
The 2nd of February.
2nd of February.
Lodge.
Your lordship, Mr. K. So is supposed to take care. Can it be taken at 2, your lordship?
At 2, I have some difficulty, madam.
Eviction orders.
Yes, your lordship.
But they have represented.
Forest.
Madam. They have represented, we have issued the order in terms of division bench, they have represented. They are trying to say that there was a forest village, which is incorrect from records itself, it reveals there was no forest village. And my lord, they are to be evicted now, madam.
Division bench has already decided the matter.
Exactly. And we have followed that, madam.
Lordship, that one order that is 251, W 251, 2025, Your Lordship, that has been, Your Lordship, Honor Apex Court has asked to maintain status quo.
No, 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 yeah, different case, my lord. It was in the context of those parties, my lord. Overall.
You go to the apex court.
In fact, my lord, thereafter, the division bench has.
But we'll have to dismiss your petition for that.
Your Lordship, can it be at 2, Your Lordship? What time you will?
Yes, Mr. Goswami,
That is too much.
that true. Yes. Yes,
Please, my lords. My lords, here the petitioner is a cooperative society comprising of the members of the Hira community, my lord. My lords is aware the Hira community is a scheduled caste of Assam who is engaged in the pottery business. My lords, way back in the year 1964 to 1970, they were allotted certain lands by the government. It was reserved in their name, and subsequently, this cooperative society was formed, my lords, in the year 1971. And thereafter, the members of the community have been engaged in pottery business. My lords, in the month of September last year, my lord, they came to know when they were accessing their lands, they were stopped by the members of the private respondent organization, my lord, saying that the particular dag over which the land was situated belonged to them. Being surprised, my lords, we had filed an RTI in the month of November, and thereafter we came to know that our dag was in fact reserved in the name of the private respondents without serving us any notice and without letting us know the reason why it was happening. If I may, Lord, take my lords to
You
page
have
number
to approach the
36.
Revenue authorities.
My
You
lord,
should have approached the revenue authority.
my lords, my lord, there was no time, my lord. Immediately we came to know that we have been deprived, my lord, without any process. My lords, may kindly come to page 36 for a moment, my lord. This is a record of rights, the Chitha, my lord. My lord, follows the top left corner, my lord, serial number 1, dag number 182 on the top left.
Page number
36, my lords.
36.
Yes. The vernacular, my lord.
Hmm. Hmm.
My lords, the top left, my lord, under number 1, dag number 182, my lords. My lords, on the left-hand side, my lord, in the comment section, my lords, it's written Mondolor Tuka, Hira Mati Udyogor Babe Hongrekhon. So, my lord, this was allotted to us. And my lords, thereafter, the private respondents, by some mischief, have also applied for this dag, my lord, along with other dags. And thereafter, my lord, the Subdivisional Land Advisory Committee had passed the resolution. My lord, will have it at page number 40. That is the impugned minutes, my lord. Page number 40, my lord, resolution 1, if I may kindly read. The committee discussed 6 numbers of proposal which were submitted by Circle Officer Sipajhar Revenue Circle in favor of so-and-so committee, that is the private respondent. The committee decided that the proposals other than those under NC Kiraka be accepted. Accordingly, the committee recommended the proposal for reservation of Jalatak land measuring 1 bigha, 2 katha 10 leches covered by dag number so-and-so, under so-and-so, 6 bigha, 0 katha 0 lecha covered by dag number so-and-so, village Badia Sandha. Next is important, my lord. 98 bighas, 3 kothas, 10 lectures covered by dag number 195, 196, 192, 181, 180, 180, 179, 182. My lords, our land is covered by only 182, my lords. Of village Kanidol under Lokrai Moza in favor of so-and-so
Your village is covered by, your land is covered by
182, my lord.
182.
Immediately, my lord, we prefer the representation, my lord. It's on the next page, page 42, my lord. In the month of May last year, my lord. So far, no reply has come to this, my lords. Therefore, my lords, I have not been able to peacefully enjoy my land, my lord, and this season, my
This
lord,
land was reserved for what purpose?
for using the land for making clay related products, my lord, to access the land for clay, out of which we are making earthen products, my lord.
Now?
Now, my lords, because this has now been allotted to this private respondents, now they are interfering with the enjoyment of our rights, my lords, over the land. And we are prevented from making the pottery business and we are not able to do it. My lord, our livelihood solely depends on this, my lords. And now at this festive season, my lord, if we are prevented, my lords, and they're also using the police to prevent us from accessing it. My lords, without showing us, giving us any show cause notice, my lord, Perhaps it is not permissible, my lord, to deprive us of this record. But
Yeah,
my lord,
for the revenue.
my lord, I had informed the learned counsel,
Who is the?
Mr. Talukdar. Talukdar is so cooperative, and for revenue, my lords, I had informed the Mr. Borpujari, Rajiv Borpujari. Madam Gayatri is appearing.
The respondents seem to be confused. Who is appearing? Huh? Mr. Borpuzari,
Yes, my lord, I am.
get some instructions here. Some land appears to have been reserved for them, but
So let it come immediately after vacation, my lord. Let me take the instruction.
21st.
My lord,
Yes.
until then, my peaceful possession may be protected.
No, we can't plus any order like that.
My lord, since we are in possession, my lord, and our lives are solely dependent on that livelihood, my lords, I kindly pray till next returnable date at least. My possession may not be interfered.
Mr. Borpuzari, counsel appearing for the revenue department, obtain instructions on the claims made by the petitioner, what is this, Somobai?
Yes.
Committee. That the land covered under DAG number 182, the village Tanidol, in the Lakrai Musa. Which was reserved for them, are under their possession for earning their livelihood by making by
The manufacturer.
manufacturing of clay products and other property items. Of the petitioner, Somobai Sumiti is a committee or belonging to the Hira community who are persons engaged in manufacture of clay products and pottery. So it is their claim that this land was reserved for them and they have been in possession since then. However, recently, they are sought to be dispossessed by the private respondent number 4 by use of force on the ground that this land has been allotted for use by the private respondent number 4. Mr. Borpuzar, we will obtain the required instructions. The matter be listed again on 21st of January. In the next date fixed, if the petitioners claim to be in possession of the said property, said land, they shall not be dispossessed without leave of the court.
FPCOP will be reflected. FPCOP standing for the correspondent number 1.
You are Mr.
K. Subjo on behalf of SK Tal.
Mr. So-and-so appears on behalf of Cooperative Society.
Cooperative Department.
Extra copies be furnished to Mr. Borpuzari and other planning things.
During the course of the day, today itself, I appear for 1 and 2, but here, my lord, the minutes of meetings had been put to challenge, SDLSA meeting, at page 40 of the repetition. This is done at the authority of the district commissioner. My learned colleague appear, but he will also take instruction, I will also take instruction. Yes.
We will resume at noon.
Absolutely.
Your Lordships, may I make a mention if your Lordships may permit me?
Okay.
WBC 3260 2022.
Writ petition allowed. No order is to post. Pending ayes are dismissed. Interim order, if any, stands admonished.
WCC 6 of 2022.
Very good. Writ petition stands allowed. No order is to post, pending I is dismissed. Interim orders, if any, stand merged.
WBC 1847 of 2023.
Writ petition stands allowed. No order is to post, pending I is dismissed. Interim order, if any, stands merged.
Much obliged.
That's a very good shit. Claim lower.
Regarding other matters, my lord.
Other matters. Bay. But isn't when it comes back.
For motion item 58.
May it please your lordship. Lordship, the petitioners are resident of village Tapaburi under Hajo Revenue Circle. So in December, fresh demarcation was done, by which demarcation was done for the village number 1 Dukani. So during the demarcation, some portion of the land of our village, that is Tapaburi.
Why have you come now again? There is an earlier order of 2003.
Yes, Lordship, 1618 WPC. Lordship, we are following it up at various levels for settlement of land. But that
Why have you come after 23 years?
Lordship, most respectfully, even during this time also, we have approached the officials. I have annexed.
This order of the court was passed in 2003.
2003, yes.
Was not complied, you should have filed a contempt proceeding. Why now?
Lordship, at page number 44, there is the page number 44 is the type copy. It was issued by the branch officer, land settlement branch. So it is not that the order was, we are pursuing to get the settlement of the land. But here in this particular land, we have been affected only in this much that the number 1 Dukania eviction is going to be carried out in number 1 Dukania village. While demarcating the number 1 Dukania, they have included some portion of our houses, which is in Tapaburi. That is the only case, Lordship. 14 families are affected because the demarcations.
Your post title says something else.
Lordship.
Your synopsis says something else.
In December 2000, yes, Lordship.
Your synopsis says something else. You are basically coming to the court seeking a direction to dispose of the claims of the petitioner. And that order passed earlier in 7/3/2003 had remained not complied with. This is your synopsis.
Yes.
What you are submitting now is different.
No, moreover, may I read the synopsis, the second part? In December 2025, a fresh demarcation of the Char area land was undertaken erroneously relying on satellite data without considering earlier land records and the 2002 demarcation certificate. As a result, portion of the land belonging to village Tapaburi were wrongly included within the boundaries of another village, adversely affecting the petitioners. Despite representations dated 1/12/2025, that is to the circle officer, and 15/12/25, immediately we approached the deputy commissioner. Seeking rectification, the circle officer Hajo issued an eviction notice dated 26/12/25, threatening eviction of the petitioners. That is our case, Lordship.
Where is the impugned notice?
Notice.
Page 67.
67. The 2002 demarcation, landmarks, and
all the barbed wire fencing, pillars, they already exist in the place, but the circle officer did not take those into consideration. And
Yes.
The PGR and lordship. You're approving the PGR and lordship.
PGR is Dukania number 1. Our village is Tapaburi. When the demarcation was done wrongly, we immediately approached the.
But without any materials to, on what basis are you suggesting that
Lordship.
this area is taken in within you?
Most respectfully.
Yes.
Immediately, because of recurrent floods, we have lost many documents. It is true, but immediately we filed RTA application seeking for geographical positioning of the details of the mapping and
Where is that representation before the DC?
Deputy Commissioner, Lordship. It is in page
60.
page 60. Annexure G.
When was it filed?
Lordship, it was filed on
16th,
16th of December.
Yes, what do you say, Mr.
Lordship,
Musumi?
it is filed on 16/12, lordship.
Hmm.
We'll consider it, lordship. We'll consider it, lordship, Deputy Commissioner.
But in the meantime, what will happen to the notice?
Well, in the representation appearing at page 60, the plea that has been taken in the present writ petition is not there. They say, my lord, there is some, my lord, discrepancies in demarcation. So therefore, they mean to say, my lord, that the part and parcel of land over which which is described in the impugn notice is actually the plot of land where they are in occupation. Now, for that, my lord, they will have to place materials, prima facie materials before this honorable court to justify that they are in occupation
No,
of this
right,
land.
but
Yes.
if they have no material, which is why they've approached the DC can cause an inquiry.
But my
Find
lord,
out.
this notice admittedly say, my lord, that this is the PGR land, my lord.
No, that is correct, but
In PGR land, my lord,
why this representation was left pending, should have been disposed of immediately.
representation, my lord, these matters are not, my lord, reflected in the representation. In the representation that is said, man, kindly see, my
It
lord.
is there, page number 61, you can see the third paragraph.
For extraneous consideration, ulterior motive with a group of people, some hope with certain NGOs for surveying and demarcation. It is pertinent to mention officials while surveying and demarcating have deliberately marked that now these dark numbers and pata numbers, my lord, these are absolutely absent in the representation. They are making a statement, my lord, but these statements are of my lord, elusive statement. Kindly see the prior portion at the, my lord, representation appearing at page 62, my lord. Kindly see for a moment, my lord. Page 62. It is therefore prayed that your honor would graciously be pleased to pass necessary order or direction not to disturb the possession of 99 persons who are the petitioners in WPC so and so. This is their prayer. And further direction may be given to survey and demarcate the village Tapaburi, ensuring that the geographical boundary so and so. Nowhere, my lord, it is stated, my lord, that there is a discrepancy. Their land is sought to be projected as PGR land, my lord, by the respondent authorities. This is not the case of the petitioners. Whereas, my lord, the impugn notice that is annexed to the writ petition at page 68 apparently goes to show, my lord, that they are in occupation of PGR land. So there is a dispute on facts. They could have filed a civil suit. Lead evidence, my lord.
I am, Lordship, I have to come with clean hands before Lordship.
Well, I'm not objecting to that.
The thing is that our Tapaburi has no issue with the revenue department. Tapaburi is all right. There is no eviction regarding Tapaburi, but
How will this court find out on what materials?
Exactly.
Lordship,
That's why. We will place our record
Who is
before the.
stopping you to place and why have you not placed it before the court? If you have the records.
Lordship, we have just applied through right to information because the records, these are concerned with records of maps which are with Directorate of Land and Records.
What is this returnable 4 weeks?
Lordship, it's not short notice, my lord. Let us get the instructions, my lord. On perusal of instruction, Lordship, maybe please to protect them in the interim if Lordship find convincing materials, my lord. But not as of,
Appears for, you were appearing for?
my lord, I am appearing for, my lord, respondent. My lord, 4, 5, my lord, 4 and 5.
Respondent 1, no.
My lord, 1 is, my lord, my colleague will appear, my lord.
Mr. N. Goswami, respondent 1, Mr. R. Borsuzari for 4 and 5.
My lord, my
And
colleague will also
4,
appear
5,
for 8, 9, 10
Mr.
and
N. Goswami for 1.
8, 9, 10 and
8, 9.
10 and 11,
10,
my lord.
11. Mr. R. Borsuzari for 4 and 5. And H. Kolita. M. Kolita for 3, 6 and 7. Respondents being represented, notices are waived, extra copies will be furnished within a period of 1 week from today. Issue notice on the interim prayer, returnable on even date after 4 weeks. 6th of February.
So I crave the mercy of this honorable court. Some protection may kindly be given.
What protection?
We may kindly not be evicted from our home. Kindly that much.
On what basis are we giving you the protection?
Also,
The eviction process will not be carried out if the authorities if the petitioners are found to be in possession of what? Topabari.
Topabari
Are found of land belonging under the Topabari
village.
Topabari village. They say it is Topabari. Here it is said, my lord, Pubongkho number 1 Dukania PGR. And dark numbers are also different.
Make at least some verification before you proceed with.
Yes, we have no objection. Deeply obliged.
But till that returnable date, my lord.
Yes.
I'm so obliged.
No, not till returnable. We are saying that you do not evict them if they are found to be in Topabari.
They are found
Yes.
to be Topabari.
That's all.
Deeply obliged.
May I please as a lordship? My lord, this is also in connection with this, my lord, the earlier matter which my lordship has just taken up, my lord, pertaining to the same area, my lord. Wherein, my lord, we have disputed, my lord, regarding the area, the claim which they have made is, my lord, falls to in a PGR land. My lord, we are occupying in the said land from the last 30 years, my lord, erosion affected persons. Admittedly, my lord, we were not the persons, my lord, original inhabitant of that particular area. Lord, we have shifted and settled there, my lord, as a government land, my lord. And thereafter, we are residing therein from last 30 years. And now, my lord, they have decided to evict us by way of a process. My lord, may be pleased to find the impugned notice, which, my lord, I have annexed, my lord, is at page 58, my lord. This is to inform you that the persons, my lord, who are unauthorizedly building the houses or doors or otherwise encroaching on land in PGR tag number so and so of Dukania village of the West Bongsa Moja under Hazur Avenue Circle, Kamrup district. After issuance, the land was ordered to be vacated and cleared of enforcement within 15 days. Otherwise, it will be legally cleared of enforcement as per the rule 18(2) of the Assam Land and Revenue Act. So, my lord, there are no options for, my lord, us has been provided that we can go before the authorities and place our case. Or the whatever the documents are there. They have straight away said that within 15 days you vacate or else we will.
But you are on PGR land.
No, my lord, it is their claim as a PGR land, my lord, but it is the, what has happened, my lord, the area has not been properly demarcated, my lord, properly demarcated. So which falls within the PGR and which area, the area which we are residing therein, my lord, is PGR or not, is not, my lord, confirmed for any, my lord, because from last 30 years, my lord, there was no objection, my lord. Suddenly they have come up with claiming that this, the area wherein we are residing is a PGR land. Now, my lord, in the notices which has been issued has also not very clear that in which area we are occupying, my lord. All the DAG numbers had only been issued, no schedule. Now, how many portion of land we are occupying, my lord, nothing has been earmarked here, my lord. So, my lord, the due procedure of law, my lord, which is required to be followed, is required to be followed before issuance of this notice, my lord. 18.2 will come into play, my lord. They have said that first you evict or else we will follow 18.2, my lord.
Let us see 18.2.
My lord.
Land revenue.
My lord, it has been, my lord, dealt with by this honorable court in, my lord, in Salekuddin's case also, my lord. Okay, sir. Let's do the last court. So, like one now. Huh? So, no. What for us, level? No. Regulation. Rule to 18.2 of the rule. It is a. A judgment to an amendment. Salekuddin of food is good.
Yes.
My lord, this 18.2, my lord, had been clarified by this honorable court, my lord, in the, my lordship knows, my lord, in the Salekuddin's case, my lord, at least 15 days. My lord, division bench judgment, my lord. So that is required to be followed. But here is in the case, my lord, they have said that you first evict, then, my lord, you will follow the 18.2, my lord. And second, my limb of argument, my lord, is that as the area has not been properly demarcated, my lord, what map or what are the, my lord, records they are maintaining is not also clear in the notice also.
Notice.
My lord, my lord.
It is very clear that if you do not vacate,
my lord,
they will resort to the process under 18.2. What else do you want?
No, no, my lord, the notice they have issued that in within 15 days they have said that we are required to be vacated, my lord.
You kindly read the notice.
Yes, yes, my lord. I have read the notice, my lord, and the vernacular also, my lord. ইয়াৰ দ্বাৰা আপোনাক বা may I read, my lord? ইয়াৰ দ্বাৰা আপোনাক বা আপোনালোকক জনোৱা হল যে কামৰূপ জিলাৰ হাজো ৰাজহ চক্ৰৰ অন্তৰ্গত পশ্চিম বংশৰ মৌজাৰ 1 নং দোকানীয়া গাঁৱৰ PGR 19, 20, 22, 23 আৰু 47 নং দাগৰ যিসকল ব্যক্তি বা ব্যক্তিসমূহে অকৰ্তৃত্বশীলভাৱে ঘৰ দুৱাৰ সাজি অথবা খেতি বাতি কৰি অথবা অন্য প্ৰকাৰে ভূমি বেদখল কৰি আছে তেওঁলোকে উক্ত স্থানৰ পৰা জাননী জাৰি কৰাৰ পাছত অহা 15 দিনৰ ভিতৰত ভূমি খালি কৰি বেদখল মুক্ত কৰিবলৈ নিৰ্দেশ দিয়া হল। So, my lord, it is an order that So, my lord, it has been ordered that within 15 days we should be vacated, my lord. So, before that, my lord, they could have resorted to 18.2 first, my lord.
This is exactly what is there.
No, no, that is there, my lord, but the first part, my lord.
Mr. Counsel,
My lord.
they have said, they have identified this is VGR, please vacate. If you don't, we'll resort to the procedure under 18.2.
No, that is correct, my lord. But whether this is a PGR or VGR, my lord, they have not asked.
Therefore,
It is their assertion, my lord. It is their assertion.
Correct. Otherwise, they will resort to 18.2. 18.2, you go and once the notices come, you go and reply.
Then, my lord, my lord can dispose of, my lord, then the 18.2 will come into play, my lord, before our eviction, my lord. My lord.
You're dismissing it.
No, my lord,
It's a petition filed on entire misconception,
no, my lord,
misreading of this notice.
no, my lord, the notice is there that within 15 days we have to vacate. Now, if we do not vacate, my lord,
Then
now
18
18 they have said, but my lord, the situation is such, my lord, that at any moment they can come and evict us, my lord, without following the 18
The
my lord.
notice itself says so.
No, that says so, my lord, but if that situation arises, my lord, we will be become homeless, my lord. My lordship knows, my lord. In a overnight, my lord, bulldoze, my lord.
What do you
Here,
say?
here, my lord, it is a notice, general notice. But schedule of the land is not required. Boundaries are not required because it is.
No, his grievance is that this notice has been issued prior to following the procedure under 18(2).
18(2) will come, my lord, in case of government land. This is what, my lord, the division bench in Salakuddin has also clarified. At paragraph 63, I have this decision before me right now. Paragraph 63, my lord, VGR, PGR are outside.
Please read 58. We are only going by the notice.
Yes.
58 or 59.
Yes.
Please read
59.
and explain to the court the meaning of the notice.
Yes, মানে ইয়াৰ দ্বাৰা আপোনালোকক জনোৱা যায় যে অকৃত্যশীল ভাৱে আপোনালোকে ভূমি দখল কৰি আছে, বেদখল কৰি আছে। তেওঁলোকক উক্ত স্থানৰ পৰা জাননী জাৰি কৰাৰ পৰা 15 দিনৰ ভিতৰত ভূমি খালী কৰি বেদখল মুক্ত কৰিবলৈ নিৰ্দেশ দিয়া হ'ল। অন্যথা অসম ভূমি আইন ৬ অনুসৰি বেদখল মুক্ত কৰা হ'ব। Now, 18(2), why 18(2) has been mentioned here? Because of the reason, my lord, that we say it is a PGR land. If they can show convincing materials that it is not a PGR land, it is a government land, then we are bound to give them a notice in the nature of show cause. That if you have any claim of a right, that means a brief.
This is not what your notice says. The notice is very clear that if they don't vacate, you will resort to 18(2).
No, resort to 18(2), it might have been my lord, drafted in such way, but the meaning is clear, my lord. It is PGR land. And Salakuddin says, my lord, that for PGR and VGR land, 18(2) is not at all attracted. Nonetheless, my lord, we have given them another leverage that if you cannot convince us that this is not a PGR land, if you can convince us, then of course we are bound, my lord, to follow the provisions under 18(2). This is what, my lord, after Salakuddin, the officers are doing, my lord, the revenue officers. Because 18(2) is a statutory protection given to any encroacher. They will have a brief right of hearing. After that, my lord, one may be evicted. They may challenge the speaking order. That is also
But
identified.
if the position of VGR, PGR is disputed.
So they have disputed. So they will have to prima facie lay convincing material at this stage before this honorable court. We are now dealing with this writ petition. Where are the materials? I am putting a question to myself, my lord, where are the materials?
Do you have a copy of the judgment?
Yes, my lord, I have it, my lord. Paragraph 63, my lord, kindly see, my lord. Paragraph 63, Salakuddin.
One notice.
Yes.
Now, my lord, our case, my lord, is that my respected friend has said that if we can, my lord, satisfy the authority that whether we are on PGR, VGR or my lord, general khas land.
Not authority, the court.
My lord, admittedly, we do not have any land record issued or we do not have any. It is purely on the government land, my lord, we are residing. That is, even my petition is dismissed, my lord, I have to submit whatever the ground situation is. From last 30 years, my lord, we were residing there in, my lord. The record shows that even, my lord, there is a provincialized school had also been established by the government in the surrounding of our area, my lord, wherein we are residing. Now, my lord, if it is a PGR land, obviously the provincialized school would not have come, my lord. Secondly, my lord, in paragraph 5, we have categorically stated, my lord, that this area is still a demarcation exercise is required to be carried out. Because, my lord, this is the very nearby is the erosion take place, my lord. Sometime the land.
But if it is PGR,
My lord.
where is the question of demarcation of the land?
No, my lord, the area nearby and surrounding, my lord, this is a very border area, my lord. That's why, my lord, the records which they are claiming, if my lordship peruse the records, my lord, what my friends.
What records have you produced?
No, my lord, we have not produced any record, my lord. We have said, my lord, we have stated in paragraph 5 that, my lord, this area is a disputed, the area has not been properly demarcated, my lord. So let the demarcation exercise carried out, my lord. My lord, kindly appreciate, my lord, these people are homeless and landless. Now, my lord, if we are being overnight, my lord, if we are our houses and structure demolished in this cold season, my lord, in this season, my lord, our life will be in danger.
What do you take for the
My
people who are evicted?
My lord?
What steps do you take? For the people who are uprooted, what steps are you
Because
taking?
in most of the cases we find, my lord, these are migrants. They move away to their, my lord, permanent places. These are migrants, my lord. These are chore areas. So people come, my lord, when they see, my lord, there is an open land, people come and, my lord, start residing their occupation, do cultivation, illegal. But nonetheless, my lord, when authorities find that they are in possession, now, just like, my lord, in this particular case, they found that they are in occupation of PGR land.
This is not a case that in a week's time or a month's time you have come to know that these people have settled. They have been settled here for years together.
No, they have not settled, my lord. They are
possession.
they are in illegal occupation.
Illegal occupation.
Illegal occupation. They are in illegal occupation, but we could have understand the situation, my lord, had it been a common government wasteland. Then we have to give them a notice in the nature of Sokot. That is what Salakuddin says. That they will have a my lord, right to Sokos whether they have any overriding interest, more so than the public interest, my lord, that they are required to be settled in that land itself. That is what, my lord, is the true meaning and purport of 18.2, which have been, my lord, interpreted in Salakuddin. Now, this notice admittedly says, my lord, this is PGR land. Jokpal Singh is clear on the point, my lord. VGR and PGR, no, nothing doing, my lord. Proxime peruse this decision, my lord. The coordinate bench decision, my lord. Once it is, my lord, PGR or VGR, no right whatsoever accrues, my lord, on the illegal encroachers. The only right, limited right that accrues to an illegal encroacher is, my lord, in a situation where a person is found to be in unauthorized or illegal occupation of regular government land, that is government wasteland, my lord. If it is a roadside land, if it is, my lord, a VGR land or PGR land, or any such other nature of land, my lord, which is specifically reserved for any public purpose, then the illegal encroacher do not have any right whatsoever, even to make a representation to the government. that look, I need to be settled or I need to be rehabilitated. This is the settled position of law. If they are in government land, which they claim in the writ petition, that there are disputes in the boundary demarcation and what
Even Jakpal conceives of giving a show cause and a brief hearing.
Well, Jakpal is suppose and brief hearing, it is there, but this is a PGR. PGR land,
Jakpal is about PGR only.
PGR, oh, it is same. It is same. But my lord, to that extent, my lord, this notice, lordship will kindly see, this notice has been issued on
But then what
20
is the point in giving you a hearing? You have no documents.
Yes.
My lord, even then, if we can satisfy with the some of the records therein, my lord.
You satisfy this court. We'll remand you back.
Petitioner is the dominus litis, my lord. He will
No,
have
you
to say the
satisfy
case.
before this court. We'll remand, you issue directions to consider your case.
No, my lord, the issue which I have raised in this petition, my lord, is that whether the area which they are claiming, even my lord, the notice has not been issued to any individual. My lord. This is a general notice circulated that how many area, in which area, what are the schedules, nothing.
What is the basis on which the government will have records as to who are these individuals sitting over this land? If it is their stand, then they're all illegal occupants.
So, my lord, in other PGR and VGR areas, my lord, the notices has been issued to the individuals, my lord, individually, that they show the records and what you have. But here is a case, my lord, they have issued a common notice, my lord. As a result, my lord, what has happened, my lord, this is a very, my lord, narrowly boundary marked area, my lord, river eroded area, my lord. So therefore, there is always a chance, my lord, that we may fall within the, my lord, general khas land and whether the PGR land. Now they have just by issuing a notice, my lord, claiming that this is a PGR land, my lord. Obviously, my lord, government is required, my lord, no doubt that the government is the custodian of the record. Now, my lord, as my lord in the earlier case, my lord has asked for the records, my lord, that what they are maintaining, my lord. In this case also, my lord, they can, my lord, satisfy this honorable court that yes, this absolutely fall within the PGR, my lord.
Don't ask for records. We said that they may carry out within the area.
If they do not fall within the, yes, within the PGR.
If you want a similar order, we'll give it to you.
But my lord, at this moment, my lord, if we have to vacate or the demolition exercise is carried out within 15 days, my lord, because this notice has been issued on 26/12, my lord. So 15 days.
We can enlarge this time by another 15 days if you want. That's the most we can do.
My lord may immediately after taking up this matter after the vacation, my lord, on the reopening day, if my learned friend come up with the records, my lord.
Why will they come up with the records? You come up with the
because,
records.
my lord, we are on possession, my lord, from last 30 years, my lord. We are on possession, my lord.
That
Now,
their statement will not do. No?
No, my lord, sometimes, my lord, sometimes we are making statement on oath before my lord, my lord.
How will this court find out? For how many years? When did you come?
No, that those issues are there, my lord. Those issues are there. The voter list.
Which place you have come to this area and taken possession? Where are these particulars?
But my lord, there are certain, as my learned friend has relied on judgments, my lord. There are certain judgments are there, my lord. If somebody is in illegal occupation of the land, whether PGR, VGR or the forest land, government should come up with a policy for rehabilitation of forest, my lord. My lord, the same issue is now pending before the apex court also, my lord.
Rehabilitation of people who have been wrongly settled or who have obtained settlement over areas by under some scheme or other thing is a different issue. But illegal occupants, and that too on a
My lord,
PGR.
my lord, with all respect, my lord, what I respectfully beg to submit, my lord. Illegal occupants, my lord, that is admitted, but we are not the, my lord, illegal migrants or we are not the citizens. We are the genuine citizens of this country, my lord.
We are not concerned that whether you are migrants or not. This is not the issue here. The issue is that you are found to be illegal occupants.
Occupation, my lord. That is correct.
PGR, VGR land, which is contrary to the law, not only laid down by the apex court. There's a direction issued to all state governments in that judgment.
No, that is correct. Yes, my lord, Jakpal Singh is also very clear, my lord. I have gone through paragraph 23 is also very clear, my lord. But only thing is that the hearing and the personal notice is required to be issued, but here they have not done, my lord. Let them carry out that exercise.
Why personal notice?
No, my lord, they may carry out the exercise, my lord. In the meantime, my lord, if we can satisfy, my lord, because, my lord, what has happened, this petitioner has come come to us, my lord, just day before yesterday, my lord, night. My lord, very hurriedly and in a very express manner, my lord, we could prepare and come up before my lord, with a apprehension, my lord, that some protection.
Yes, Mr.
My lord.
Borpujari can be lenient to give you another 15 days. We have no
Lord,
difficulty
we'll
extending.
produce whatever document we have, my lord, before the authority. They will consider that observation, my lord, can.
You come up with any documents on 19th.
My
if
lord.
You have.
My lord.
And if you are satisfied that yes, there are some documents.
I
we
will try.
See what
I'll try.
order we can pass.
I'll
Right. Mr. A. Borvian, Learning Council to the Mr. Arbo Pujari, hearing for
Well, my lord, respondent number 1.
respondent number 1.
My colleague will appear for 2, 3, 4, and 5.
Mr. N. Goswami for 2, 3, 4, and 5. Therefore, notices are being furnished within the course of the day.
My lord. Today itself.
The petitioner is agreed that by the notice dated 26/12/2025 issued by the circle officer, Hajo Revenue Circle, whereby petitioners were informed by the general notice that they are sought to be evicted as they are unauthorizedly building houses or occupying on PGR land covered by DAG numbers 19, 20, 22, 23, and 47 of number 1 Dopania village of West Bongsa Moja in the Hajo Revenue Circle, Kamrup district. The petitioners have been asked to vacate the land within 15 days from the date of issuance of the notice. Stop. Mr. A.R. Bormia.
A.R. Bhuya,
A.R. Bhuya, sorry, submits that the petitioners have been residing in these plots of land for past several decades, and these notices were not issued on personal names, individually, but a general notice was issued. Therefore, the petitioners could not gather the sufficient materials before to place the same before the court that they have validly occupied the lands and are not unauthorized occupants. The Learned Council therefore submits that the interim notice be stayed. Better. Mr. Arbor Puzari, on the other hand, strongly objects to the submissions made by the writ petitioner, referring to the judgment of the apex court in Japal, reported in so as also in the judgment of division bench.
Yes, Salakuddin, my lord. That is, my lord, I'm spelling it out, my lord.
Reported in so and so.
Yes, my lord, it is judgment and order dated, my lord, 27/6/2024, passed in WPC 1057 of 2022. 27/6/2024, passed by the division bench, my lord, in WPC number 1057 of 2022.
Referring to the said judgment of Salakuddin, Learned Council for the petitioner submits that the judgment has authoritatively held that where the occupation is on PGR land, procedure prescribed under Regulation 18(2).
Yes.
The Assam Land and Revenue Regulation 82 is not called for. Eviction from PGR lands stands outside the scope of Regulation 18(2). So, be that as it may, considering the fact that the counsel for the petitioner submits that the notices, although stated to have been served on 26/12/2025, petitioner has received a copy very recently and has approached his court by filing the writ petition. He prays for enlargement of time to furnish materials before the court to support the contentions raised. Accordingly, let this matter be listed again on 19th of January. The respondents will not proceed to evict the petitioners till the next date fixed.
My lord, that's Salakuddin citation is, my lord, I found it is 2024 4 GLT 857. 2024 4 GLT 857.
And what is Jakpal?
Jakpal is, my lord, this is 2011 11 SCC 396. The paragraph under Reliance will be, my lord, para 23.
Yes.
And so obliged.
Obligement.
That would be the Yes.
Lord, this is a mosque, my lord, before my lordship, my lord. But my lord, admittedly, this mosque is located in a, my lord, Vizier land, my lord. Lord, what has happened, my lord, though they have said that the notices have been issued, but unfortunately, my lord, after filing of this writ petition, my lord, we could receive the notice, my lord, today, my lord, while we are in the court premises, my lord. So, my lord, I am very sorry, my lord, I could not annex this with the petition as well as, my lord, could translate it also, my lord. So, it is required to be brought on record, my lord. But only thing is that, my lord, we are apprehending the, my lord, eviction from the said area, my lord, that they have said within, my lord, 7 days, we were asked to submit whatever record we have, my lord. But as the notice was not directly served to us, my lord, that's why we could not proceed, my lord, with the said
Notice was
instruction.
issued on which date?
My lord, notice was issued on 3/12/2025 in this notice, but
When did you receive it?
my lord, the petitioner says, my lord, that the yesterday night, my lord, only they could find out this notice, my lord, from the office. That's the difficulty, my lord.
And in
Now, my
the writ petition, the prayer is for setting aside and the impugned notice dated 3/2/25. That notice is not annexed.
No.
They have the knowledge of the date of notice.
That is correct, my lord.
And my lord, the intent of the
Filed
notice.
the writ petition on 8th of January.
No, my lord. That is correct, my lord. But we have not, my lord, may
After 1 month, more than 1 month.
kindly verify, my lord, the annexures, my lord, only we could annex only one document, my lord. Had the notice been in our possession, my lord, we could have annexed, my lord. That is not in our possession, my lord. That's the problem. The manner in which it has been served was also not proper, my lord. So, my lord, may I pray, my lord, that as they have said that we could submit the documents within 7 days, my lord, can it be, my lord, from today, my lord, within 10 days, my lord, we will submit whatever we have, and then they will decide, my lord. Vizier judgment, my lord, that the Jakpal Singh judgments, my lord, in paragraph 23, my lord, it has been said that, my lord, if the land is used for the public utility service, then there is an exception has been provided, my lord. So those, please, my lord, we can take before the authority also, my lord.
You bring it on 19th, Mr.
My lord.
Pujari?
My lord.
My lord, an interesting facet is here, my lord. The next item, that is item 61, it is identical and similar.
They received.
Yes.
There, that the notice dated 3/12/25 is annexed.
Annexed.
Here it is not annexed. Same council.
No, council is same, my lord,
more,
the petitioner is different, my lord. There is nothing hide and seek, my lord.
I did
Admittedly,
not
my lord.
submit anything more, my lord.
No, please. The council.
No, my lord, the word council is a
My lord,
personal attack, my lord. The word council is a personal attack, very
I am
unfortunate.
not attacking.
Lord, my lord, if my lordship dismiss my case also,
My
my lord,
lord's
I
attention
will
to
not
the
hide.
materials on record. I'm not attacking. I'm just drawing my lord's attention to the materials on record. Of the 2 writ petitions which are being moved by same council, and in 1 writ petition, the impugned notice has been
He
annexed.
admits that it
My
was not annexed. You received it.
My lord.
What more can be done?
We'll bring it on record.
Let us see the next matter.
61. This is also a mosque, my lord.
But the name appears to be similar.
Belgori Notun Bazar, Panjagana Masjid, my lord, and this is Belgori Jame Masjid, my lord, building.
Yes.
Slightly, my lord, area, there is a distance between both the
No.
mosques, my lord.
In item 61,
And both are on Vizier land.
My lord, they have said that it is on VGR, my lord.
now Lordship will, in the second item, Lordship may kindly see the notice appearing at page 34. Page 34.
There's some hearing on 12.
Yes,
One.
yes. This notice is
You go and
issued
present
on,
it.
My lord, here, my lord, what has happened, my lord, the authority, my instruction is that, my lord, though they have appeared, my lord, but the no document they could submit, my lord. So, my lord, therefore, another, my lord, opportunity may kindly be
Yeah.
provided, my lord, here, my lord.
No, what opportunity? You go and apply, you go and approach the authority. Why have you come to the court? If there are any documents available.
they were
No, no,
given
my
the
lord,
opportunity.
we approach, my lord, at
They will
page,
not oblige.
page,
with,
page 37, my lord, my lord may kindly have a look, my lord, the next page is at page 36, my lord. We have approached, my lord, page 36. On 11/12, my lord. This has not yet been, my lord, taken on account, my lord. Any order has not yet been passed, my lord, but we are apprehending that we may be evicted, my lord. Maybe, sir. Budget committee is also absent.
When did you file the application for allotment of 1 bigha land?
My lord, it
No
is.
date is there.
My lord, it is at page 30, my lord, annexure 1. Hmm.
2003.
My lord, my lord.
Then.
Then, my lord, there is no action the department has taken, my lord, and this is pending there. And now they have, my lord, waken up and said that this, as this is a, my lord, visual land, so you vacate, otherwise we will demolish, my lord.
No, but you did not pursue it. What happened on?
My lord, that is a lapse, my lord, on the part of the petitioner. My lord, as these records are there, my lord, this has been acknowledged also, my lord, by the authority, my lord. My lord.
Look,
You
for a
can sit,
moment,
you can file an application and sit tight for couple of decades. And then turn around and blame the government to say that they have not taken it.
No, my lord, that is also correct. Sometimes it happens, my lord, in village areas, my lord, people are not so conscious, my lord. When there is nothing happens, they also sleep tight, my lord.
Lordship will kindly see, my lord, the notice at page 34. For a moment again, my lord, I am troubling, my lord. It is dated 3rd of, my lord, December 25. And now it is stated in the notice, my lord, page 34, the hearing will be held on 12/12/25. Lordship will kindly see, my lord, to whom the notice has been addressed. It is Belgori, Notun Bazar, Panjagana Masjid, shop, etc. Kindly see. It is not only the masjid. They have set up shops. And kindly see the representation, my lord. They say, my lord, that they have participated in the hearing process. And page 36 is the translated copy. Page 36 doesn't say, my lord. Page 36 doesn't say anything about existence of any, my lord, religious institution, for that matter, any masjid over the plot of land. It says, my lord, that they have, my lord, constructed temporary shops, everything. Commercial activities are being carried out, my lord, in VGR and PGR land. So they have been given the notice. They were given sufficient time. And kindly see, my lord, the next page, page 37. This is the vernacular. Kindly see the conduct of the petitioners. This vernacular is in fact not submitted before the authority. It doesn't carry any seal and signature, acknowledged.
acknowledgement, seal and signature. It has not been provided to us, my lord. I have inquired, my lord. It has not been sometime, my lord. So the entire story is a false story.
Orders, can we give it to you, give you now?
No, my lord, we will go, my lord. We will further submit the whatever document we have, my lord. Another 15 days time may kindly be given, my lord. If we cannot satisfy, then we will have to vacate, my lord, admittedly. But one thing is there, my lord, that in Jakpal Singh's case, my lord, in paragraph 23, it has been said, my lord, from my limited understanding, my lord, that if the land, visual land is used for public utility service, then, my lord, there is an exception, it can be regularized. Now, whether this mosque can be constituted as a public utility service, my lord, that they can decide, my lord.
Right.
Right.
Let us keep it on 19th.
My lord,
My lord, 19th.
Until 19th, my lord, not to be. My lord.
Don't proceed in terms of the notice. And the petitioners will furnish all necessary documents before the competent authorities in support.
Then, my lord, before 19, let them, my lord, furnish.
Before 19.
Yes. They will furnish.
My lord.
Yes.
Today is 9th.
Today is 9th. Let them furnish it by 17th. After vacation. By 17th. They have difficulty, we also have difficulty, my lord.
No. Let them furnish on, is 15th the working day?
17th.
15th.
15th is not a working day.
For state.
Yes. So let them furnish by 17th, my lord. My lord can take it up on after the reopening. Let them furnish it by 17th, my lord. Lordship will
Alright,
take.
then if they furnish by 17th, then what orders will you pass on 19th?
No, on 19th, my lord, we can come up before my lord with all the materials, whatever they have submitted.
Alright.
And our decision. Therefore, lordship is protecting them till 19th.
The petitioners will furnish their documents in support of their contentions that they are not illegal applicants. Question. At the earliest, before the competent authority, not later than 17th.
Yes.
Of January. Matter will be listed again on 19th. And till the next date, the eviction process under the said notice shall not be resorted to.
My lord, they will submit before the circle officer, Samaguri Revenue Circle, that much.
In both the matters.
Yes. Samaguri Revenue Circle.
Furnish relevant material before the circle officer, Samaguri Revenue Circle.
Samaguri. My lord. Oblige me. I'm obliged, man.
I think really thick.
Where is the CGC?
You just hear, my lord. He made an inquiry, my lord, not been evicted. In fact, my lord may kindly peruse the photograph.
Yes, Mr. Gupta.
My lord, taken instruction, my lord, they are in possession. But the fact is that, my lord, this is a government quarter. And
you take steps.
And my lord, the employee who had died, my lord, in the year 2015. And as per the rule, my lord, maximum 2 years, the family can retain.
Bring everything on record.
My lord.
Third learned counsel for the parties issued notice. Returnable following Mr. H. Gupta, learned CGC appears for the respondent. All the respondents. Petitioners are aggrieved by which order?
There's no order, my lord. The essential supplies have been disconnected, my lord, water and electricity.
By the action of the respondents in disconnection of electricity and water to the quarter number Roman 3-A type 2 at the Relief Yard Colony Lumbing, which was allotted to the late father of the petitioner, namely late Sanjit Malakar, who died in harness on 22/5/2015 while serving as SFW-2/2 NF Railway Lumbing. Stop. The learned counsel submits that this being a public premises, the procedure mandated under the Public Premises Eviction of Unauthorized Occupants Act 1971 is mandatorily required to be resorted to before the authorities can seek to evict the petitioner who's residing there with her mother. Stop. However, that not having been done, the respondent authorities have disconnected the water and electricity supply. Correct. When the matter was called up, the learned CGC took liberty of the court to obtain instructions as to whether the eviction has been carried out and to apprise the court during the course of the day. Subsequently, when the matter was called up again, learned CGC fairly submits that the petitioner is still in possession of the said water. Accordingly, the learned CGC, however, submits that the father of the petitioner expired in the year 2015, and under the rules, they're entitled to retain the water for a period of
2 years from the date of the death.
2 years from the date of the demise of the railway employee. Therefore, the petitioners are not entitled to any protection to be retained in the said waters without any authority. Be that as it may. Let notice issue returnable 4 weeks. The respondents will complete their instructions and file necessary affidavits, and matter be listed again on 4th of February. Until the next date fixed, if the petitioners seek, if the respondents seek to evict the petitioners, then the same shall be done by taking recourse to the PPE Act of 1971. Meanwhile, the essential supplies of water and electricity will also be restored.
Forthwith, minutes. Kindly. No electricity.
Immediately. When were it disconnected?
Well, 16th water was disconnected, 18th electricity was disconnected. Port was closed, man. We couldn't find.
Right.
I'm deeply obliged, man. Very grateful, minutes. Obliged.
My lord, in this case, lordship, the petitioners applied for allotment of the land, lordship. Their application is pending, annexure 6, page 33, lordship. All the applications. And thereafter again submitted, lordship, the in a page, annexure 7 is the original copy, page 37. But without considering our application, the authority, district authority is now contemplating to allot the land to the others, lordship.
Only one video of it.
Huh?
Yes.
That I pray, lordship, our appeal is also pending. Since page, original copy is page 47 and 48, lordship, which is an English version is translated copy is page 44. That also not yet been considered, lordship. So my respect to submission, my lord, let notice may go, lordship, and in the meantime, my learned friend may take instruction. I pray, lordship, and my representation.
Parties issue notice written in 4 weeks. Mr. N. Goswami, the government advocate, appears for the respondents.
2, 3, 4.
2,
3, and 4.
2, 3, and 4. Therefore, notices are waived. Extra copies be furnished within a period of 1 week. Since it is the case projected by the writ petitioner that the appeal preferred by the petitioner before the DC, Ujai, will remain pending. Pendency of the writ petition shall not be a bar for the DC to consider and pass effective orders on the application.
Lordship. Lordship, and in the meantime, Lordship, not to allot our land because we have a Lordship house, a pakka, everything, Lordship, Indira Awas is there. We are residing in that. We have also paid the land revenue since 1981. We have original copy of all this up to 2018, Lordship. So I pray, Lordship, till the decision of this honorable court, Lordship, not to make
We have
it
filed an appeal also pending.
pending, Lordship. Till consideration of our appeal, Lordship.
The appeal by the DC, the allotments ought to be made.
Lordship.
Shall not be proceeded with.
Lordship. Much obliged, Lordship.
Item 56. No, 6.
May it please, your Lordship.
Yes.
Lord, on the ground that we are occupying forest land, a notice was issued. Notice was issued on 17/12, Milord. And we submitted a reply on 30/12/25. And on the same day, Milord, a cyclostyle order has been issued. Now, all that I'm praying for is, Milord, let them give us a personal hearing and then pass an appropriate order. Kindly see the nature of the order, same order passed in respect of all the cases. End of the day, Milord, we are occupying this land for last 3 decades. So we are in possession of documents. We'd like to place it and, my Lord, let them give a personal hearing and pass an order.
Yes, Mr.
Otherwise, our stand is clear, my lord, that apparently they are inside a forest, my lord. They say it's a forest village, but there is no document to indicate that, my lord. If they agree with that, my lord, I am agreeable, my lord. Let them file a representation. They will give them a personal hearing. Whatever document they have, my lord, let it be produced before the DFO. He will take a fresh call.
DFO.
Yes, DFO has passed the order, my lord. Let him revisit the order, my lord. Sorry, issue, my lord. Let them file their representation along with all supporting documents, my lord. If they can make out a case, that's a different thing, my lord.
Let the date be fixed within a period of 2 weeks, my Lord.
Let them file within 10 days, my lord. Thereafter, we'll decide, my lord. Because otherwise, my lord, date was still 15th of January for them to vacate the place, my
Vacate the
lord.
premises.
So within 10 days, let them file a representation. We'll give them a personal hearing and then we'll take a decision, my lord.
I've heard Mr. K. N. Chaudhary, learned counsel for the petitioner, then Mr. P. N. Goswami, learned additional AG appearing to the respondents. The petitioners are agreed by the eviction notices dated 17/11/2025, followed by orders dated 30/12/2025 issued by the DFO, Hailakandi.
Hailakandi Forest Division.
Division.
Hailakandi Forest Division, whereby the petitioners are sought to be evicted from their homestead, which the forest department claims is within the reserve forest area.
Inner Line Reserve Forest, my lord. Name of the reserve forest is Inner Line Reserve.
Inner Line.
Inner Line, my lord.
The petitioner, however, dispute this stand of the respondents and submit that they have got sufficient documents in support of their contentions, which, however, could not be placed because before the DFO for paucity of time. If the time is enlarged, they would like to file all necessary documents before the DFO Hailakandi in support of their contentions, and thereafter DFO can pass effective orders. The submission of Mr. K. N. Chaudhary, learned senior counsel, is not disputed, is not objected to by the learned additional AG. He, however, submits that if the respondents can file their representations supported by the necessary documents in support of their contentions within 10 days from today.
My lord.
Before the DC, before the DFO Hailakandi Forest Division.
We'll revisit the impugned order, my Lord.
Then the Hailakandi DFO, Hailakandi Division will examine the documents, and if any germane grounds are found, then the
Appropriate order
authority
will be
will
found.
revisit the order. Correct. In view of the submissions of the council at the bar, this court closes this matter at this stage without issuing notice. So the petitioners will file their representation before the DFO, Hailakandi Forest Division, within 10 days from today, along with all supporting documents and materials. The DFO will thereafter examine the individual cases of the petitioners and pass appropriate orders thereon. And if the materials are found to be genuine and germane, then the respondent authorities will pass appropriate fresh orders in each of these cases
Till then, my lord, status quo as on today.
till the next date, till the matter is so disposed of by the DFO, Hailakandi, the status quo will be maintained.
Co-op petitioners, my lord, there are others. Status quo.
Who are the petitioners?
For the petitioners,
And my lord,
till the who are the petitioners.
one more submission, my lord, if they don't file, some of them do not file a representation, we'll proceed with the earlier order.
All of the petitioners do not file their representations in.
We'll proceed according to our
liberty
order.
granted by the authority. The forest department is at liberty to proceed in the. matter
According to the
orders already passed.
deep level. My lord, in one paragraph, my lord, when my submission was recorded, my lord has recorded respondents have filed, will file representation, it will be petition.
Petition.
Deep level, I think.
Deep.
What happened with that, Madam?
My lord, here, my lord, pending appeal, my lord, they have freeze my bank accounts, my lord. Pending appeal, they have freeze my bank accounts in violation of section 6, subsection 6 and 7 of 107, my lord.
Who is for the respondent?
State GST is there.
Where is state GST? Yes, Mr. Chaudhary.
Lordship, I have received telephonic instruction. They are under process of communicating with the bank to defreeze the account either by today or by Monday, since tomorrow is bank holiday.
We'll record it and dispose.
Yes, Lordship.
My lord.
Heard Mr. R.S. Mishra, learned counsel for the petitioner. Mr. B. Chaudhary, learned standing counsel. State GST.
Yes.
Mr. Chaudhary on instruction submits that the department is in the process of liaising with the bank authorities for defreezing the account in terms of the provisions of section 1076 read with 1077 of the CGST AGST Act 2017. So he therefore submits that the defreezing is likely to be ordered by is take effect within the next 3 working days.
Yes.
Since the submission is made on the basis of instructions, this court, by recording these submissions, considers it appropriate to close the present writ petition. As no further orders are called for. The bank authorities will defreeze the account in terms of the instructions received by the state GST. As expeditiously as possible.
Much obliged.
Only 13 to WP 2 to 3 of 26.
Lord, this matter is similar with the item number 8, my lordship is these two fixed on 29th, my lord, and they have said that they will file an affidavit, my lord. This Tongia cultivation titular paper, my lord, my lord.
Yes. Some are similar, but there are few facts I like to point out, my lords. Their whole claim is based on a rule, which is rule for establishment of control of forest villages. That very rule has been set aside by a learned single judge, which has been upheld by the division bench of this court, my lords. And that apart, my lords, if it is similar to if that be so, my lord, will also address this issue there, the affidavit, and that it is fixed on 28th, let it come on 28th. That all these facts have to be brought.
This matter to be fixed on 21st.
29th of this 28th, my lord.
28th.
Item number 8, my lord.
Similar.
And my lord, there is an interim direction, my lord.
Yes. 28. Let this.
28
along with.
Another different.
The respondents submit that they would like to complete their instructions and file necessary affidavit in support.
My lord,
Those are-
along with,
those are the-
my lord, along with WPC, my lord, 37391 of 2025, my lord.
7391
2025, my lord.
of 2025.
My lord, there was an interim order in that no coercive action may be taken. Similar order may be possible.
Similar order, but only the query petition.
No coercive action be initiated against the.
Query petition.
File.
Query petition.
File.
All.
Oblige.
That's fine.
My lord, this is a matter, my lord, regarding that PGR and VGR land issue, my lord. Notice has been, my lord, issued to us. But my lord, here is a case, interestingly, my lord, no notice had been issued, only miking had been done, my lord.
What has been done?
Miking, my lord, by in a auto rickshaw van, my lord, they have fixed a mic. Miking had been done, my lord, no notice had been issued, my lord. We have asked the petitioners, my lord. So, my lord, by following the due process of law, my lord, they will
On
issue.
what basis there is no notice?
No, my lord, that miking, my lord, in many areas, my lord, wherein we are, my lord, coming
Where
before
is Mr. Borpujari?
revenue.
Annex, my lord, here.
Huh?
Notices are annex, my lord.
Annex?
Yes, my
Page
lord.
number?
Page number 50, my lord.
50.
Alaluddin, my lord.
It will know, this is Faizul Haq and 56. Milord can fix it on 19, Milord. They will produce that if notice is issued, Milord, will follow the instruction of the notice, Milord.
What? This is.
But Milord, admittedly, no notice, Milord, has been personally served to us, Milord, to petitioners, Milord. Paragraph.
No notice, then you can't be evicted.
But my lord, miking had been done in the area, my lord, and
You are also occupants in the VGR land.
VGR, my lord. They have said that we are in VGR land, but my lord, in some of the nearby areas, allotment had been given, and patta lands are also there, my lord.
Petitioners claim to be residents of land in Belguri Kachari Gaon village under the Samoguri Revenue Circle. Petitioners submit that petitioners express apprehension that they shall be evicted from this land on the basis of announcements made through loudspeakers by the revenue authorities that they are illegal occupants of the PGR, VGR land and therefore are required to be evicted. Stop. However, no notices have been served on them. Stop. The respondent authorities are not posted with any instructions. Accordingly, matter be listed on 19th January, by which date the respondents will complete the instructions as to whether any notices were served on the petitioners seeking their eviction from the PGR, VGR land. Until 19th, if the respondents seek to evict, till 19th, the respondents will not proceed to evict the petitioners except otherwise by following the due process of list on 19. Although notices are not issued, extra copies be furnished within the course of the day. Mr. Bhuiya, you have to furnish copies today.
Yes, sir. Milord, this is connected with item number 61, Milord. These are the shop owners, Milord, wherein we have been issued notice. Milord, the Masjid committee has allowed us, the Milord, some of the area of the Masjid in the frontage of the road, Milord, to be used.
Orders will be passed there?
My lord.
What orders was passed?
Milord, that on 19th, Milord, we are required to produce some records, Milord, what we have done. So, Milord, exactly similar, Milord. 61, Milord.
We forgot what orders we passed. What orders was passed in that matter?
My lord, that order was passed there in item 61. My lord, we have to, my lord, submit by 17th. By 17th, my lord, the documents before the authority, and they will examine, and by 19th, my lord, my lordship will again take up the matter, my lord.
61.
I don't know. How powerful is it?
Not a line.
Competent মানে হেৰি circle officer.
My lord, circle officer, Samaguri Revenue Circle.
Circle authority, namely circle officer. Samaguri. Same order. Same order.
My lord. My lord. Oblige, file oblige.
Same order.
Here I am appearing for one, my lord. My learned friend will appear for circle.
We are fixing it on 19th.
Yes, my lord.
Yes, 19th.
Oblige.
Extra copies be furnished.
May I please? My lord, here, my lord, the impugned eviction notice that your lordship will find at page 35. Page 35, my lord. Yes.
Yes.
Yes, my lord, this notice, my lord, is in, my lord, contravention to the order passed by the Honorable Supreme Court in a related, my lord, matter. That lordship will find page, my lord, 25. Page 25. My lord, the order passed by the Honorable Supreme Court, and operative part, my lord, page 26. From, my lord, paragraph 2, my lord. Honorable. This apprehension, my lord, paragraph 2, this apprehension in our opinion is misplaced for the tenor of the order which is impugned in this special leave petition is merely to direct the Deputy Commissioner to proceed against the unauthorized occupants in accordance with law, which presumes that the Deputy Commissioner must examine the claim of the each occupant on case-to-case basis, and after recording satisfaction in light of the evidence produced before him, proceed to the pass appropriate order as per the law. We may
add that if that order is adverse to the occupants, the deputy commissioner must give reasonable time to the occupants to take recourse the appropriate remedy as may be permissible in law. In other words, the deputy commissioner shall decide the proceeding uninfluenced by the observation made by the High Court in impugned judgment and order. It will be open to the deputy commissioner to request the High Court to extend the timeline specified in terms of the impugned judgment and order, whose request we are certain would be considered appropriately by the High Court. Beside this, nothing is more required to be clarified. This is presently petition are disposed of accordingly. Now, the PAL, which has been referred in the challenge before the Supreme Court, that has also been pending before this Honorable High Court.
Then
Now, once the matter is sub judice before the Honorable High Court, after the order passed by the Honorable Supreme Court, so this notice is not maintainable.
No, I have not understood. Supreme Court has passed an order directing the deputy commissioner to examine the claim
Yes.
of each of the occupants.
Yes.
Then after that, what happened?
Yes. After that, the matter is pending before this Honorable High Court, still pending.
Why?
That PIL, after the Supreme Court's order, that PIL is pending before this Honorable High Court. We have annexed the order,
No, the apex court directed the deputy commissioner.
Deputy Commissioner. Yes.
Then what happened to the
Now,
orders passed by the deputy?
after the direction by the Supreme Court, Deputy Commissioner has done nothing, till date, we have not heard.
That is
On the spirit of the Honorable Supreme Court order, each and every case has to be heard by the Deputy Commissioner. But the Deputy Commissioner is sleeping over the matter last 5 years. Now suddenly issued the eviction notice.
It means they must have passed or you may not have filed the.
No such order. No such order has been even we are not heard. Unless we are heard.
This was passed on 29/12 when you are coming on the last day before the vacation, right? That too by making an unlisted.
It was only issued on 29.
29.
Yes. And immediately on that day, we have filed representation before the Deputy Commissioner also.
Why did you file representation?
Because Deputy Commissioner is not acting as per the Honorable Supreme Court order. Page 37, Lordship kindly see. On the same day.
Such as Deputy Commissioner directed to petitioner to produce the documents, Lordship. They can file the documents, Lordship. Deputy Commissioner, in the notice, Lordship, impugned notice, Deputy Commissioner directed the petitioners to file documents, Lordship, to establish their claim.
Yes.
It is according to the Supreme Court order, Lordship, if I understand correctly, Lordship.
Yes.
Now, page 37, Lordship kindly see, that is also pending before the Deputy Commissioner. That has to be decided in the spirit of the Honorable Supreme Court order.
What 35 is the notice issued.
Yes.
You are asked to file documents.
Yes. Yes.
Before the circle officer.
Yes. But time limit is given, unless within 1 month from the date of notice, receipt of the notice, they will be evicted, That is the more serious, to the petitioner. Now, as per the Supreme Court order, Deputy Commissioner has to decide the fate of the order. Now, he has not decided the matter, but suddenly issued the eviction notice.
Where is the eviction notice?
Page 35. And vernacular Lordship will find at page 36.
When after the Supreme Court's order, when did you file the documents?
Now, Supreme Court order, after the Supreme Court order, we filed application before the Deputy Commissioner on 6/2/2020.
Where is that?
We have indicated page 37, Lordship policy.
The indication will not do. You have to file along with all documents.
Yes. We have mentioned here, 6/2/2020. page 37, my lord.
You have submitted the above order.
Yes.
We are asking you in terms of the directions of the apex court,
My lord.
when did you furnish the information?
Yes. No, that's true, that's true. But the deputy commissioner is, my lord, has not, my lord, given any, my lord, notice
Right,
to
Mr. Ravi Mandal, learned
to produce the records.
in deference, in terms of the order dated 3/2/2020, passed in SLP number so and so, page number 25. The apex court passed the following order, page 26, 27. So, parent. It is the claim of the petitioner that without the compliance of the directions of the apex court, the impugned notice dated 29/12/2025 has been issued. Mr. N. Goswami, learned State Council, submits that the impugned notice dated 29/12/2025 is a direction to the petitioners to produce the documents before the circle officer to substantiate their claim of hold in the tribal belt, and failing which steps will be taken for eviction from the land. We find that the contention of the counsel for the respondent is correct. The impugned notice at the first instance directs the petitioner, permits the petitioner to file necessary documents before the circle officer to substantiate their claim. Stop. Even otherwise, in terms of the apex court order, the petitioners were required to file their necessary documents in support of their claim, pursuant to which the concerned DC will examine each claim and pass appropriate orders. The petitioners have not been able to satisfy the query of the court as to the date when these documents, as permitted to be filed by the apex court, were filed before the DC. We therefore permit the learned counsel to complete his instructions, learned counsel to the petitioner, to complete his instructions in this regard. Matter therefore be listed on 30 January.
Till then, my lord, status quo at least, my lord. Otherwise,
Status quo.
if we are, my lord, evicted, my lord.
You are evicted by your own fault. You did not file anything in terms of the Supreme Court order in 2020.
Yes.
6
We have
years,
filed-
you did not do anything.
We have filed immediately, my lord.
No, you did not. You just filed the copy of the order before the DC.
Yes.
You are asked to file documents.
Till then, my lord, status quo, my lord. If, my lord, eviction is done, my lord,
Eviction is done, you'll have to go to move
then
to some other.
our
place.
writ petition will be, my lord.
We can't allow such, directions not being complied with blatantly. His directions are at your request in your favor, yet you don't comply.
Yes. Definitely, my lord, they have submitted the relevant documents,
You are unable to point out,
including the order.
not including the order, only the order. That is what the letter says.
Yes.
Which was not necessary because the state was represented before the apex court. They would have got their orders.
Yes. That is
Why
there.
take the trouble?
It might have been submitted before the tribunal, but the indication is that
You give
order.
us, you give us get copies of the application on the next date to submit that these are the documents which is filed on such and such date.
In any case, my lord, till my lord, the next date, my lord, status quo at least, my lord. Otherwise, if they are evicted, my lord, what will be the fate of the writ petition, my lord?
We don't know, it will become infractions, we'll dismiss it. What can be done? The basic foundational facts, you'll have to place it before the court in the matters of eviction.
In that case, we will file, my lord, additional affidavit bringing all
Please,
these.
please do. Yes.
My lord, date may be fixed, my lord.
We have fixed it, 30 January.
30 January. Can it be earlier, my lord?
You tell us when you want it.
Immediately after vacation.
Immediately. 21st.
My lord. Obligation.
Item 6, WBC 216 of 26.
Please, Lordship, the petitioners, my lord, are the patta holders, my lord. Along with the pro forma respondents, my lord, what happened, my lord? This land was purchased by, my lord, their predecessor interest, my lord. And in fact, my lord, the civil suit is also pending, my lord, with regard to, my lord, the partition of the suit land, my lord. There's an order of injunction also. This suit was filed with the petitioner, my lord. Now, what had happened, my lord, in the meanwhile, there is a bit of finance commission grant, my lord. Lordship will find that at page 76. Now, my lord, over the private land of the petitioners, a road is being sought to be constructed, my lord.
Municipality, no?
The Hailakandi municipality, my lord. Page 82, my lord, is a diagram, my lord. This is a road actually running through the middle of our, my lord, Pattaland, my lord. Now, with this land, with this same land, my lord, the civil suit is pending. There is an order of injunction, of course, my lord. That's again the private respondent, my lord, within the my lord, respondents themselves, private respondents themselves, because my lord, it's a partition suit. Now, the petition, there is no process initiated, my lord, no, my lord, notice, nothing whatsoever. And now they're constructing the road. I've given some photographs at page 94, my lord. Within our my lord, land, my lord, constructions have started, my lord. Page 94, my lord, the photographs, my lord. Now, my lord, this is actually, my lord, a fraud on public money, because without, my lord, in the middle of public grant, my lord, how a road can be constructed in the private land, my lord.
What is the status of the civil suit?
Civil suit, my lord, that's a
Civil suit is between whom?
my lord, within the the co-partadas, my lord, for partition. That's only partition, sir.
Then how is it relevant? Why they mentioned this?
No, mention because, my lord, this is the same land just to make a mention. That's why I brought in, my lord.
No, but with different causes of action.
That's different cause. There's no relation at all, my lord. There's no relation at all.
They get instructions.
There is a Hailakandi municipality, notice to go, I'm not representing you.
Earth Council for Parking Just.
I'm for 120.
Mr. N. Goswami appears for
120.
120. Therefore, notices are waived. Extra copies be furnished within a period of 1 week to public. Steps on respondent 4, 5, 6.
4 to 14, my lord.
Is a pro forma.
The pro forma.
You're not claiming any relief.
No.
No notice at this stage. 4, 5, 6. Be taken by speed post as well as usual course. Notices on respondents 7 to 14 are not issued as they are pro forma respondents. Matter be listed again after the returnable date.
Well,
after the returnable date, because your primary respondent is not before the court.
But in the meantime, if the construction is done, my lord, they will be
You should have served copies, advance copies.
my lord, the municipal board, they have no council, my lord.
You serve it on the municipal board.
That's, my lord, it had to be hurriedly filed, my lord. Otherwise, my lord, status quo today may be maintained, my lord. Otherwise, my lord, the
What
construction.
status quo? They are already constructing. What will happen after that?
Well, if the construction is completed, my lord, the entire, my lord,
Construction is completed. You are entitled to. It's only a claim for money.
Well, that's true, my lord.
Only a claim for money. So we'll examine that. This is not a case that your house is being demolished and a road is being constructed.
No, that is of course not the case. Yes. So the Pattaland, my lord, also.
He issue notice on the interim prayer. 3 weeks corridor. List on 30. Yes.
Can it be, my lord, a shorter date, my lord?
It is to 3 weeks notice we are issuing it. We thought we'll issue 4 weeks, but we brought it down to 3 weeks.
We will be allowed to maybe take the service.
Yes, Dusty, service of notice by Dusty is permitted, subject to the same being routed to the registry of the court.
Obliged.
Item 7, WBC 224 of 26.
Milord, this is also similar with item number 8, Milord. That is Tongia Reserve Forest case, Milord, similar. Some of the persons, Milord, left out. 73 are here, Milord. Milord can fix.
19.
No, Milord, 28.
28.
January.
The Bormone Lucia order. Do you have the number of the writ petition?
Yes, yes, my lord, the.
Huh?
7391 of 2025, my lord.
7391.
My lord.
It will order the petition. On 20, when is it fixed? 28.
28th of January, my lord, and till then, my lord, no coercive action has
Yes.
been directed.
Similar orders.
My lord. Obliged, highly obliged.
Lady list. Order item trustee to trustee.
Lordship, these are the matter where Lordship has pronounced judgment today in 3 matters.
We go through the judgment.
I'll go through the judgment and Lordship may fix after vacation.
Dr. Saraf, we have passed the judgments today,
Hello.
3 of them.
I have already submitted the written submission in 3 cases.
Oh.
Other 3 cases, my lord.
Another 3 cases.
34, 37.
33, 34,
37.
and 37. All the petitioners submitted their respective arguments written.
No,
up.
no, no, yeah, let me, 33, 34, 37, my lord, I have submitted my written submission.
33, 34, 37.
My lord, because the facts will be all, in all cases, different. So at least these 3 cases, your lordship may reject the judgment, my lord.
Let them first go through it. On the next date, we'll reserve it if required.
My lord, even if it is lower point is covered, but the facts will be altogether different. my lord.
We would not like to reserve it. We'd like to deliver it.
Well, unless we reserve, the judgment will also not come, my lord. If it is not inconvenient, my lord, your lordship may
All
reject.
right, 33, 34, 37 reserved for judgments.
I am highly obliged. There's matter, lordship may come after vacation, lordship, I will go through judgment and I'll.
Yes, yes, go through it.
Much. In item number 30 also, I have filed the written argument.
You go through the judgments that we have delivered today. Come back. Matters will be listed after 4 weeks.
Number 40.
Well, the IA we have filed for vacating the interim order, my lord.
My lord, in this case, I am praying for some more time for filing objection, lordship. One line, it's the senior has filed a IA for vacating the interim order, lordship. I'm praying for some more time to extend maybe given.
Lord, we have some urgency, kindly give a date, my lord. If not, if possible on 28, my lord.
28,
28 what?
28.
Lordship.
All right. Matter be listed on 28. Permitting the counsel for the opposite party / the writ petitioner to file their objections in the matter. Mr. D. Nath for the applicant.
Applicant.
Based on 28th.
28, lordship.
Judgment.
Obliged.
Supplementary list for order second 62.
এই বুঝবেন ঠিক করলে বলে যাচ্ছে
My lord, I am here, my lord, imputed respondent number 10 and 11, my lord. As per earlier order, my lord, perhaps, my lord, writ petitioner side also not submitted amended first title, my lord.
But no, there's a direction to file the amendment by the added respondent. But I have also filed an application for interim order. Other day, I submitted before the coordinate bench, but things there, I am the one, I am the in possession, I am the patta holder. The college authority is trying to, they, have you also got it, my lord? I am audible, my lord.
You have Mr. Borbia is appearing for respondent 10 and 11.
10 and 11,
Newly-
implemented, my lord.
The direction was upon them. Because I have also prepared a amended my lord, petition, my lord. But my advocate is there, my lord. He's appearing partially before lordship. He can file it. But direction was that your lordship kindly see the order. The newly implemented respondent represented by Sri A.M. such and such, the learned counsel is required to file affidavit of opposition within a period of 4 weeks
The amended
from
cost.
today, and also to file amended cost title.
Normally, my lord,
That dates are upon them.
I have filed, my lord, no problem.
No, no, this is the order.
My lord, my lord.
This is the order.
But,
This is the order.
That is there.
You file it
But
with.
I have,
one more.
Let him file it.
I have,
My lord.
but kindly hear me. I have also filed an application for interim order. The
And my lord,
college authority is trying to make a garage, it is trying to nature and character of the suit poverty. But other day also I submitted before the coordinate bench. Kindly give some protection. Kindly give some protection. In paragraph 7, I have pleaded the urgency of the application. Paragraph 7. So that is
What is your IA number?
IA number. What's that? Well, kindly give me something. Kindly, man. But I am hope.
And they have not submitted, my lord, copy of the writ petition to the respondent, my lord.
You have not submitted copy of the writ petition to the newly implemented respondents. You have to submit.
Yes, I've submitted, but that is. But IA number 165 of those 2026.
It's not available.
Filing on 7 January 2026.
It's not available. Probably not come.
Does not come. But I am told that is on the file, my lord. Though it has not been listed. I may be wrong, my lord. I do not know, my lord. I am told. For the Ladi advocate record.
Who is the advocate on record? Is he available here?
Earlier occasion, one person appeared, my lord.
Do you have a local counsel here? Is there a local counsel?
Not
Local council. Yes, local council.
He is not present here today.
Oh, he is not present here.
All right, list this matter again. On 30 January.
On, my lord?
On 30 January?
Well, this is so urgency. One of the college authorities is trying to make a garage and change the nature and character of my property. I am in possession. That is urgency. It's the early day, that is my humble submission before Rossi, my lord. Kindly, my lord.
It is a playground of the
Oh,
college.
but first you'll have to serve copies to the new,
I shall serve. But I shall serve, my lord.
because this court is closed for 1 week. Next week the court is closed.
Court is closed in Calcutta also. Our court will be closed on and from 25 up to 26.
Wonderful. So,
And on 12 is also closed in Calcutta High Court
oh,
for the birthday of Vivekananda. Swami Vivekananda.
so you can come and visit Guwahati in the meantime.
Oh.
On 22nd?
22nd.
Yes.
But 23rd is Saraswati Puja, your lordship knows.
Oh.
But 21st. But Saraswati Puja, your lordship is a Bengali, Saraswati, Ma Saraswati. It is about books.
You must come and see the Saraswati Puja in Guwahati.
Oh,
It's unique.
Guwahati, in my family, in my house, but I am the priest also. I am the lawyer, and for ideal of Saraswati, I do the.
All in one.
And my wife will say, don't go there. From very beginning, I am doing it. But I am the Brahmin. That is this.
All right. 20. Then let us have it on 28th.
28, yes.
Yes, all right. Based on 28th, the respondents, newly implemented respondents 10 and 11 will file amended post title. And the petitioner will also ensure service of copies of the writ petition on respondent 10 and 11.
And IA, my lord, claim to be filed, my lord.
The IA stated to have been filed, praying for interim orders, is not listed before the court. Registry will trace out and connect it to the case records on the next day.
Amended petition filed by the added respondent.
You have not even served copies of the writ petition. First, you have to serve copies.
If I have to serve, and they will file. Otherwise, I may file the amended petition. I may file.
Yes, you can file.
That we are doing here also. This is our duty because you are the writ petitioner. lies upon you, you find it. Oh, I can find it.
Right, right.
I shall find it. But I shall try to go to Guwahati and appear personally before her.
Yes,
I shall try.
you're welcome.
Yes,
You're welcome.
Oh, yes, I get to it.
Okay, we have filed an application for getting stay. On last occasion, they have taken time to file reply. But my submission will be also within 256(3) have lied. So the interim order passed on 3/9/2024, get automatically vacated.
Where is that?
Lordship will find at page 15 the interim order.
Page?
Page 15 of the IA. And there is civil litigation pending between the parties, and they have already obtained an injunction order on the basis of the High Court's order. And that is a property dispute and civil litigation is pending, and Lordship will find the injunction order dated 18/9/2025. On the basis of this High Court's order, Lordship, page 22. Allegation is, Lordship, on the basis of the FIR, police has not taken the action. FIR at page 30 of the repetition. No cognizable offense has been disclosed at page 30. And already there is an injunction order from competent civil court. And Lordship, as per 226, full bench judgment has clarified that it is automatically vacated. After, Lordship, the application has been filed and was listed.
When did you file it?
It was filed on 2/12/2025. Thereafter, it has been listed on 12/11/2025. Interim order has not been extended. IA, Lordship. IA has been filed on 2/12/2025.
2/12.
2/12/2025.
It was listed on 19/12.
19/12.
1912, huh?
Interim order has not been extended.
It's agreed to by the parties.
Not agreed. They have taken time.
The order says agreed to by the parties. 19/12.
I have not verified the order, Lordship.
It's there, you can verify it now.
Lordship, but interim order has not been extended.
What is the meaning of agreed to? The agreed to by the parties for listing these IA. Now, if this interim order is vacated, what is the point in hearing the IA?
As per full bench judgment, Lordship is aware, the full bench judgment of this honorable court file, that is, Lordship, reported in 2024 4 GLT 779.
Now, what about the pleadings?
Pleadings, we have filed the affidavit in opposition. And they have filed reply.
They filed reply.
The first time the matter came up on 1912, the IA Milord, which you have filed vacating. Now, as per the full bench decision, the date of filing or application has been considered to be the date first listed before the court. On 1912, it was first listed before the court. Now, on that day, as agreed by the party, matter was directed to be listed on 7/1.
By this time, it is expected.
Now, Lordship, kindly consider 7/1, it was directed to be listed. 1912, the court matter was listed, and with consent of both the parties, it was directed to be listed on 7. Now, once the court has considered it and said that both the parties have agreed that the matter should be listed on 7, can it be said that the 14 days limitation will be applicable on that basis? And secondly, my lord, the ad interim order which was passed earlier, after that they have filed affidavit. Now, once it comes to the notice that the ad interim order has been passed, 226(3), the object is that in the absence of some party, the ad interim order was passed and an application is filed for vacating the stay, and the stay is not vacated. The application not disposed, it will automatically be vacated. The affidavit in opposition was filed. Second affidavit in opposition was also filed. And in that affidavit, they have stated that the interim order may be vacated in the affidavit in opposition. Now, thereafter, they are invoking 226(3). You know, the object of 226(3) is not that once the party comes to know, they file the affidavit, and thereafter they file the second affidavit, and thereafter say that that order is to need to be vacated. And my learned friend is saying, my lord, that an injunction, they filed a civil suit, it was dismissed. We filed a civil suit, the injunction was granted. Now, what is the order? Interim order? That the protection will be granted, because at that time the FIR was that the protection was not granted by the police, and the court directed, because the some goons were going and damaging, my lord, the taking possession of the land. Now, once the injunction order is already there, that if the court vacates the order, that means the police will not protect.
The injunction order is to what effect?
Not,
My lord,
injunction order, Lordship will find at page,
What is the?
page 32. Restrain us.
so what is the interim order passed by this honorable court?
Restraint from alienating page 27. Page 27. In order to, their Lordship, they are claiming right on the basis of adverse position.
You are filing on whose behalf?
Lordship,
Who are you?
I am the title holder of the property.
Hmm.
They are claiming adverse position on my property, and they are claiming right on the basis of adverse position. And now on the basis of the High Court's order, they are now, day before yesterday night, they have started construction with land. We have also filed an FIR before the officer in charge of Disubari Police Station.
There is no
Day
construction. nothing.
before yesterday, we have the photographs. They have
My-
used JCB
my
and other
lord-
things and started construction.
My lord, when the petition has been filed, I must have the chance to give the reply to that. Now, my lord, the 226(3) petition was filed. It came up for consideration the first time on 1912, on which both parties agreed to, and the matter was taken up on 7th. And the 7th,
This page number 18 in your IA is the injunction order.
Lordship,
In whose favor?
in my petitioner's favor.
What is the finding of the court?
finding Lordship will find at page 22. Page 22. Lordship will find petitioner have also adduced the order of the Honorable High Court dated 3/9/2024, passed in WPC case number Iman. On the basis of that, this interim order has been
No,
passed.
no, no,
Basically,
no, no. Absolutely incorrect. You'll also see the merit. Yes.
So the court directed
Already there is civil case is pending.
the opposite parties means you.
Lordship,
You are restrained from alienating, transferring the suit line,
yes, Lordship.
and from changing the nature. This injunction is there,
Injunction is there.
right? And this interim
Lordship,
order.
we have to file appeal against this order.
Hmm.
If that High Court's order stand, our appeal will not.
What is the effect of the High Court's order?
High Court's order is to restrain the police, and that order has been quoted in order dated
Restraint.
injunction order that has been quoted.
The order of the High Court at page number 17, the effective part of the interim order is at para 11.
Para 11.
Right?
Lordship.
So para 11 is till the next discernible date, more particularly will ensure possession of the petitioner shall not be disturbed.
I'm not disturbing his position. Actually, land was under my position.
The interim order was directed against the state authorities.
In the state authority to protect the interest. Lordship is aware when civil case is pending in respect of an immovable property, in respect of which injunction has been obtained. Reed Court will not entertain a petition.
The council.
Lordship, understand that.
We understand that. We are trying to understand the effect of this interim order of which you are seeking a vacation now. This interim order perhaps merely says that the possession of the petitioner's possession shall not be disturbed and it should be ensured by the OC of the concerned police station. That's all.
Lordship.
Now, assuming this order is not there, otherwise also the injunction.
He is
order
protected.
says-
He is protected.
So how are you affected?
My affection is, Lordship, against this order, I have to prefer appeal before
Which
appeal,
order?
appellate authority. And Lordship
No,
will
no,
find
against
it
which order?
against the order of injunction.
You prefer?
I can prefer,
Uh.
but it will affect me because Lordship will find at page 22 how it order has been passed. Page 22, middle portion.
That is only.
Petitioner have also
facts.
adduced the order of the Honorable High Court dated 3/9/2024, passing WPC case number Iman. Learned counsel for the petitioner submitted that the order of the Honorable High Court is still in force. In the said order, Honorable High Court has directed to protect the position of the petitioner, also directed not to disturb position. Petitioner of the said case are the same of the petitioner of the said case. On the other hand, this has affected me, Lordship.
Why?
Because if this order stands, lower court will not interfere the injunction.
That is a presumption.
Not presumption, Lordship.
Yes, that is a presumption. How can you presume that the appellate court will refuse to interfere because there is a.
Lordship, if there is a High Court's order.
No, no,
respect-
what is the effect of the High Court's order? It is right in front of you. See,
Well,
the
Lordship,
High
see
Court's
page 239.
High Court's order is a direction to the OC so-and-so police station to give protection.
Lordship.
That's all. It doesn't decide on the title or the property or anything.
Admittedly, title is with me, Lordship. I am the title holder.
Whatever it may be, the matter is before the civil court, you go and decide, you go and agitate before that. But there is an injunction order against you. Against you, there's an injunction order.
Injunction order.
Right. So your remedy is before the appellate court.
Appellate court.
You have to go and file an appeal. But
Lordship, there is no restriction of filing appeal.
Right.
But if when civil case is pending,
Yeah.
Lordship is aware there is a Supreme Court judgment on this point. When civil court is pending, civil suit is pending between the parties, really same matter. There are two suits.
So we'll hear you. That can be a ground on the IA. That may be a ground on your writ petition. That
Lordship
there is a
kindly
civil
see-
suit pending.
Lordship will
On the
kindly see
same- on the same issue, you cannot have two different proceedings.
May I submit, Lordship, one thing?
Yes.
Lordship, kindly see the full bench judgment, which I have quoted.
Hmm.
Last page. Last page.
Hmm.
Third line. The term date on which it is received. 2060 will count. Third line.
Hmm.
Last page, third line.
Hmm.
The date on which it is received would therefore mean the day of the application for vacating of an interim order is listed before bench endorse the roster to take up the petition. Here, Lordship, the date has been fixed on 12/11/2025.
1912.
1912. Thereafter, Lordship will find para 45. Accordingly, 226(3) of the Constitution is not a directory provision. An order referred to Article 26(3) of the Constitution is an ad interim order. Said interim order is required to be limited. Duration, in other words, the existence of an interim order has to be limited to the date so fixed. The interim order is converted to an interim order only after the opportunity of being heard is granted on the prayer of the interim relief to all the parties of the proceeding. High Court on an application under Article 26(3) of the Constitution may reject the application or vacate, modify, or alter the interim order, or may extend the interim order in presence of the parties. There is no extension order to the lease. Once the interim order is extended after hearing both the parties, it shall be converted into an interim order. And prescription for automatic vacation of the interim order for not being disposed within 2 weeks cannot be applied. However, the High Court can still vacate the interim order on various grounds. So interim order is not extended, it automatically vacated.
Yes.
So my submission is this, Lordship, on the, without going to the merit of the case also. Full bench
We'll
judgment.
hear you again on
My lord,
20.
only one thing I must submit, my lord. I learned a friend. The first time 1912, the matter was listed. as per the full bench decision, the time will start from 1912. Now 1912, both the parties agrees that the matter may be listed on 7th. Well, can it be said when both the parties agree that the matter may be fixed on 7th on the one hand, and thereafter say that the time limit will expire 14 days?
That's what we pointed out, that once you agree the matter should be listed, it is deemed that the interim order is extended.
If Lordship, consider this Lordship,
See,
if deemed to be Lordship.
according to you, on 1912, on 7/1, the matter was listed. It was listed on 7/1,
7/1,
right?
lastly.
Huh?
7/1 also it was not continued.
No, sorry.
1712 first.
Sorry, 1912.
1912,
1912 was a first date.
first date.
Now, on 1912, you agreed that the matter should be taken up on 7/1.
Because we have said, Lordship, we have filed an application for vacating stay. There is
No, no,
urgency.
no.
IA was on
This
there.
order on 1912 is passed in your IA only.
That is on IA.
1912 is passed in the IA only. So on the day when it was placed before the court, you agreed that we'll take it up on so and so date.
But interim order has not been extended.
For what purpose are you fixing it on the next date if it is not for vacating the interim order? If on 1912 the interim order was not extended, why did you agree to extension for listing the matter on the next day?
Because court has no time on that date.
Whatever it may be, whatever, for what purpose? Then you should have insisted that the interim order stands vacated.
I think, Lordship, the main writ petition, it has been recorded because our submission was there is a urgency in the matter. That is why, Lordship, the case has been fixed on last day.
And in any event of the matter, vacation, non-vacation of the presence of the interim order does not restrain you from filing an appeal against the injunction order.
My humble submission, Lordship, as I understand, Lordship, if High Court's order stands, we will not get any relief.
On what basis?
Because of the Lordship, the lower court also recorded the High Court's order.
You show the order, you show the order actually passed by the High Court and impress on the appellate court that this is the order passed. May not have been accurately recorded
Lordship,
by the trial court.
Not
I
a single,
just
ensure
see page 25, once whether on the basis of the High Court's order the injunction was granted. Your Lordship, just see. Page 25, the last paragraph starts, my lord. The petitioner side has cited the decision of the Honorable Supreme Court in so and so. The petitioner side also cited another decision of the Honorable Supreme Court in so and so. Thereafter, also seen the decision cited by the petitioner in so and so. Considering the circumstances appeared in the case in hand, submission of the learned counsels, order of the Guwahati High Court passed in so and so, and in view of the principles laid down by the Honorable Supreme Court in the aforesaid decisions, I am of the opinion that it is necessary to protect the protection of so and so as interim injunction granted in favor of the petitioner by restraining so and so, in order to protect the position of the petitioner as well as the presumption so and so. It was on the basis of all the Supreme Court decisions.
It is not your case that the interim order.
Lordship, my submission to the Lordship. If Lordship do not like to pass an order, this full bench judgment, Lordship may fix this matter immediately after vacation for considering the petition for vacation.
No, we are trying to understand it. This is not a case, it is not your case that the interim order was obtained by suppression or misstating facts. Not like that.
No, Lordship, we have taken a stand in our
interim order is essentially a direction to the state authorities to give them protection.
I can
And
show from
so long the injunction order
I can show from the writ petition itself how this order has been obtained.
That is a different issue. So if you are saying that no, it is on suppression or
clever drafting, Lordship. It is a clever drafting.
It has to be clever drafting.
It is a clever drafting. Showing that, Lordship, FIR has been filed by someone. FIR has been filed by someone.
How can you find fault with somebody being clever?
Drafting
FIR has been filed by someone. FIR has been filed by someone and stating that police has not taken action. Police will register a case when there is a cognizable offence.
So and so is intelligent, therefore.
Malati, compliments on the advocacy record that clever drafting.
Lordship, always I have a compliment for him.
Or my advocate record.
All right.
Well, what I will pay, my lord.
Yeah.
Lord, I may be granted time to file a reply to the
interim, the IA has been filed. And thereafter, my lord, the matter may be listed. You'll also consider it. And
Immediately after vacation, Lordship. By this time, they can.
I cannot take my due time to file the reply.
Let us have it on 27th of January.
Yes, Lordship.
And in the meantime, the interim order may continue. Otherwise, again, the same thing.
Lordship may not pass this order.
Well, otherwise, the same thing will arise. Again, he's saying.
Presume.
No,
As
it's
agreed.
not- it is not
As
presumed.
agreed, as presumed.
No, no, no,
Otherwise,
no.
it will become an not interim order.
No, it cannot be.
As per full bench judgment.
That is the.
But if we extend the interim order, then the
It
IE must fail.
Full bench judgment.
No, you also will say that only up to that date.
As agreed, Lordship.
Still consideration.
If we extend the interim order, then the IA has to fail. It's 226(3).
No, 226 my lord, your lordship can always consider your lordship is not disposing of the IA.
No.
Your lordship is disposing, will hear the IA on 26(3), on 27. But
As
if it
agreed,
is,
Lordship.
yes, as I am saying both agreed.
Or we list it on 20. Let it be on 20.
But again, the same thing will arise, my lord, that the order it is there. And no, my lord, again, the same point will be raised that the interim order was not there, 14 days expired.
No.
Your lordship may at least record it. My lord, at least your lordship may record it.
All right. Third counsel for parties, the IA has been filed. Seeking vacation, notification, alteration of the, seeking vacation of the order dated 3/9/2024, passed in WPC 4477 of 2024. The petition, the applicant, namely the opposite respondents number. Your respondents?
I am respondent, Lordship.
6
Sole
and 7.
respondent.
6 and 7.
6 and 7.
Respondent 6 and 7 in the writ petition submits that this is an application under Article 2263, and therefore by efflux of time, the interim order dated 3/9/2024 stood vacated on 19/12/2025, as the interim order was not extended on that date. Dr. A.K. Saraf, Dr. A. Saraf, on the other hand, strongly objects to the submissions made. He submits that on 19/12/2025, when the matter was listed, it was on the consent of the parties that the matters were further directed to be listed on 7/1/2026. Therefore, when the parties had already agreed to have the matter listed on some other date, it cannot be accepted that the counsel for the applicant was unaware of the fact that this will have the effect of extending.
Copy.
Be that as it may, let this matter be listed again on. When do you want it?
Well, it would be better if 28, if you also want to hear it on 26, because
Lordship,
I have to file a reply also, my lord.
Lordship, my submission to be Lordship, exchange of affidavit has been done in the main writ petition also.
So you then
For
the
final
main,
disposal.
then the main
Let us hear
petition,
the writ petition instead of
then
the IA. Why are you pressing the IA then?
I also
If you are
important,
pressing the
Lordship.
IA, then you have to give him an opportunity to file something.
Lordship, in last occasion, it was listed before another court, and court was interested to dispose this petition because view of the court is different.
my lord, your lordship is here one thing, my lord. Just, my lord, if your lordship may, 2 minutes, my lord. My learned friend says that interim order has been vacated by so and so. Then 226(3) is, the application itself should be, is not maintainable. There is no necessity of 226(3). Either he must say the interim order is continuing, then 226(3) is there. If interim order is has already gone long back, where is 226(3)? Both the sides, on the one hand, he's saying 226(3). Then on, he's saying that the interim order is gone. And last time I just see on the scene, I'm pressing for long.
No, we'll hear you on 27th. 27th of January. The
My lord,
respondents.
My lord,
the-
if
the
26th or
petition-
something, my lord, 27, 28, the learned friends will not be available. 29th or 26th, I have no problem with. Or 26th already, my lord. 29,
29th.
one day, my lord, here and there will not make any difference. my lord.
29th.
29,
29th of January, on which date the petition, the petitioners / the opposite parties in the IA will ensure that their objections are filed.
my lord, till then the interim order must continue. Till 29th, my lord. We are also considering what IA, my lord.
It will affect the full bench judgment also.
How it will affect? I will place the full bench decision. You will also just see this order of the Allahabad High Court. Well, how it will affect?
From 12/11/2024, interim order has been extended.
I am just placing, you'll also see paragraph 3, the third line, my lord. The words till the next date of hearing implies that the case is listed and some further order is passed. I do not agree that the words till the next date of hearing should be interpreted literally. If a narrow and so-and-so interpretation is given on the words, it will lend to so-and-so. Now, what is the order in the last date? Till the next date of hearing. Till the next date of hearing means, listing means, my lord, some order is passed.
No, then what is the point in filing your objection? We can close this IA.
That will be listed on 29th. I will not file an objection also.
Or at least again on 29th.
29th, my lord.
The question of extension or otherwise of the interim order will be considered again on 29th.
But if in between, my lord, I'm just saying, lord, this will consider taken that in between there is no interim order. Now, if some steps is taken by them,
No, they
that-
can't because you are protected by the injunction.
my lord, injunction order is there, but the portion of police election there, if that goes, nothing. That was the reason, my lord, that the writ petition was filed. If I'm not protected up to 29th, once the injunction is there, what is the harm in protecting me up to 29th?
It will affect the full bench order also.
What full bench order will be affected? There is no full bench order. How it will be affected?
Full bench has specifically stated,
Till the next.
as I
date,
understand.
The interim order dated so and so will continue, which however.
Reconsider.
Will not prejudice the claims raised by the applicants in their.
In the IA, my lord, I have no objection.
To be decided on the next week.
Absolutely.
Because Lordship, it has affected the full bench order. Full bench has said,
We'll examine that.
the full bench has said, if interim order is extended in presence of the advocate, it will amount to extension.
Correct. Therefore, we said it will not prejudice your claims raised in the IA.
Lordship has already held that consent order, it is already immediately
Your
extended.
lordship has
If
directed,
consent
my
order
lord,
It is not held. We have recorded his submission.
Huh.
If consent order is there, Lordship, then the extension is there.
We have not held. It is their submission. We have recorded their submission.
And your lordship said that it will not
We have
prejudice the claim.
extended the interim order with a rider that it will not prejudice your
Claim in the IA.
your claims in the IA. Meaning thereby, that whether it is vacated, not vacated, will also be decided. So,
I'm highly obliged, my lord.
Oblige us.
For applicant item 43.
Your Lordship, this is the regard to appointment of an arbitrator. The respondents,
yes,
We were agreeable,
Huh?
agreeable for the same, lordship.
agreeable.
Within 1 month.
Your Lordship may appoint an arbitrator, Your Lordship, from the panel. Section 20,
Let us have it on the reopening day because it will require a
detailed order.
dictation of the order, the facts and everything.
Matter.
List again on 19th. Is agreed to by the council for the parties.
45.
My lord, in this case, what happened is that, my lord, the petitioner along with her deceased husband had taken some loan from the Austal Allahabad Bank. They have not yet, my lord, we have repaid the loan in totality, but they have not yet returned the original papers.
2 weeks time, my lord, by the time, my lord, we'll get the instruction.
Third counsel for parties, Mr. So-and-so, learned counsel appearing for the respondent bank.
My lord,
Bank
my lord, Indian Bank.
submits that he be granted 2 weeks' time to complete his instructions in the matter. List again after 2 weeks on 4th of February.
Very well, my lord.
My lord.
46.
Matter list, my lord, issuance of DRC 01 only without there being a so cause notice, my lord, the order was passed. It is otherwise covered by lordship, so that I have furnished on last occasion, my lord. The lordship has held, my lord, DRC 01 cannot substitute so cause notice, my lord. DRC 01 cannot substitute so cause notice, the lordship has held.
Who is for the respondent?
State GST is there.
Disposed.
47 is also similar, my lord.
Similar.
My lord. Much obliged.
There's 48 and 49.
My lord, this is old pending case. It was adjourned because of the pendency of central organization case, my lord. Central organization case, my lord. So central organization case has
For
been
the
disposed
respondent,
on 20, my lord.
Railways.
20, it may be taken up.
20.
Yes. Very old case, my lord, 2019 case, my lord.
All right. List again on 20 on the request made by the counsel to the petitioner as the standing counsel NF Railway is not present in court. List
Both the cases.
Yes.
Much.
I think 50.
None appears for the petitioner on call. Mr. A.K. Learned CGC is present. And Mr.
A Gugoi Lopez, case number 6.
A. Gugoi for 6. Mr. N. Goswami.
And 2, 4, 5, and 6.
2,
4, 5, and 6.
2, 4, 5, and 6. List after 2 weeks.
That is 65 and 66.
Hello. Respondent was supposed to bring the instructions regarding, respondent was supposed to bring the instructions regarding allowing
Who is the respondent?
B. Gogoi. I sit here,
N. Gogoi appears for the petitioner. The respondents are not represented. Therefore, the matter stands deferred to be listed again on 28
hello.
January.
67.
Wait, please, is your lordship. Your lordship, while last order dated 9/12/2025, the respondents were to obtain instruction with regard to whether re-verification has been done or not after the institution of this writ petition. Otherwise, the writ petition pleadings are complete. Reply has been filed. This writ petition is regarding the cancellation of the sale permission. They have already been issued in favor of the petitioners by the office of the District Commissioner, Kamrup Metro at Guwahati. But later on, when they went for registration of their deeds, then they could found that the NOCs have been cancelled by the authority on the basis of a letter written by the circle officer.
Yes, any Instructions by any respondent?
One affidavit we have filed also.
Huh?
Affidavit I have filed also.
And from their affidavit also it is visible at page number
We'll
75.
take it up after a week.
Can it be on 19?
Huh?
Can it be on 19?
No, it can't be.
20th?
Like we can attempt on 20th.
20th. Deeply obliged.
List this matter again on 20.
Deeply obliged.
As it is submitted, the pleadings in the matter.